I am Ranjan Singh and I will be there with you for the Indian Polity section of this QEP program. As you may be aware that the notification is out and we are few months from the prelims examination. Some of you may have prepared, some of you may have not gone through revision also. So this quality enrichment program of our institution aims to give you a holistic idea about the topics that are important from the prelims point of view. Now, when we analyze the questions which have been asked in the Indian Polity section in the past years, what we have seen is that in one of the prelims examination, 22 questions were asked, in one 18 questions were asked, and even in one of the prelims examination, 9 questions were asked from the Indian Polity section. So we don't have any trend as such, and even if we talk about the trends, the only trend that is there with the UPSC is that it has no trend. That is the only trend it has. It has no trend. So that is why what we'll have to do is, we will have to develop an idea about all the aspects which are important. There are certain aspects which we do not touch also. Questions are never asked from them. Yes, for the purpose of continuity, we teach those topics in our foundation classes, but in the examination, the questions are not asked. So we will, in the coming classes that you will be there with me, I will try to cover all the topics which are important for solving the questions which will be asked in the examination. And one thing that we have seen in the recent times with respect to the prelims examination is that mugging up certain facts is not going to solve the problem. There were years or days when we needed to mug up all the articles of the Constitution. Even today also, you may have seen your friends, so-called seniors also. Seniors in the sense that those who have been preparing for long, 4 years, 5 years, but they have not competed even in the prelims examination. They will ask you, hey, what is this article? What is this article? Then they will try to create a panic that, you know, I have remembered all the articles, but even though I have not cleared the prelims, hey, you don't know this. So the simple answer here is that you tried to mug up all the articles. That is why you have not competed in the examination. Because UPSC examination is not a quiz contest that they will be asking you what is Article 3, what is Article 2, what is Article 5. It is not like that. And an understanding of certain aspects is, it is not constitution only, it is polity. How the system actually works, that we need to know. So if with the help of the smart board, I will discuss with you the process for the creation of a new state, and then if I say that it has been mentioned in Article 3 of the Constitution. So for you, the process for the creation of a new state is more important than mugging up Article number 3. No one is going to ask you, hey, what is Article 3? So we need to develop an understanding about the things. Then no one is going to ask you that which article of the Constitution deals with the Council of Ministers, but which of the following statement is correct regarding the Council of Ministers. Statements will be there that the Council of Ministers comes into existence as soon as the Prime Minister takes oath. Even the Prime Minister alone can constitute the Council of Ministers. Then a minister can be without a portfolio also. Such type of statements will be there. So if you have not understood how the political system really works, you will not be able to answer these questions, even if you have mugged up all the articles of the Constitution. Then, so we are not supposed to mug up the articles as such. Another important thing is that with respect to the case laws, what we have seen is that in the Indian polity section, some of the questions have to be answered with the help of legal approach, that is the judgments of the Supreme Court. Here also there is a misconception among the students that we will have to mug up all the cases. It is not like that. You'll have to just remember the case, certain cases and the judgment. And because you see, in the prelims examination, 4 options will be there. Like in which of the cases the Supreme Court upheld the judgment of the Keshwanand Bharti case. So the name of 4 cases will be there. You are not supposed to mug up versus this, the year also. It hardly matters. Then apart from it, other aspect, even in the main examination, you are not supposed to remember the whole thing. Keshwanand Bharti v. State of Kerala case 1973. There is no need. Even if you don't know versus State of Kerala case 1973, it hardly matters. Because if the question is asked on the basic structure doctrine, in the Keshwanand Bharti case, the Supreme Court gave the judicial innovation of the basic structure doctrine. The examiner is not going to come to your home and ask that, hey, you have not written the year, you have not written verses. It will save your 4 words also. That is smart work. But student who will do hard work, he will feel good. I remember versus State of Kerala case. So what? So what? Versus State of Kerala case. Keshwanand Bharti case itself is a landmark case. So in a flow, if you write, ignorance is not a crime. Writing a wrong fact will be a crime. These aspects, most of the students do not understand. And then they say, polity is very difficult, because they have done hard work, not smart work. This is the thing that we need to understand. Now, in this QEP program, we will try to discuss the constitutional aspects, but not article wise. There is a particular pattern of reading Indian polity. It is not about article wise as it is there with the others. And it is not Lakshmikant. Yes. The other misconception in the whole market is that misconception is the Bible. It is Lakshmikant is the Bible. You have read Lakshmikant. So what? Students sit in the class, sir, I have read Lakshmikant 4 times. Sir, then even you are not cleared the prelims examination. And the irony in this country is that anyone who is preparing for the post of the peon to an IAS officer, he moves with the book Lakshmikant. Everyone. It is a fashion symbol nowadays. Special courses on Lakshmikant. I will teach you Lakshmikant word by word. What is that? Yes, YouTube में देखो, it भरा हुआ है. Yes, Lakshmikant course. It is not a Bible, Bhagavad Gita, that you are teaching it to the students. It's a key book है. वो तो रहता तो everyone would have competed in the examination. तो लेके घूमो, देखना एक भी पेटी नहीं होगा तुम्हारा. Yes, because I am not criticizing the particular book. The teacher is not criticizing means the teacher knows nothing. Who asks you to read Lakshmikant's book? It is not a teacher who has specialized in political science, but The teacher who is a failure, who himself had read that book, he had not completed, he has started teaching. You need to go beyond Lakshmikant's book. Go beyond it. You'll have to do some value additions. Then only you will be able to complete. So, our QEP is not limited to Lakshmikant, or we can say any specific book. It is a holistic course that will give you an idea so that you will be able to answer the maximum questions which will be asked in the examination. Now, a workbook has been given to you. We will be following the pattern which is there in the workbook, but apart from it, the space that may have been given in the workbook may be lesser. So you can use your own notebooks also, so that at the end of the day, this notebook will be a comprehensive guide to you. We'll start with the basics because the questions are from the basics also, and then we will be winding up with the most current aspects of the Indian polity sections, like which bills have been passed in the year 2023, what is their significance, what questions can be asked. All this will be the part of this course. How many of you are from the non-political science background in the class? Okay. How many of you have opted for PSIR as an optional in the class? So there are many students who have not taken PSIR as an optional paper. Now, so that is why we will be starting with the scratch also, because the questions in the examination are from the basic things. Now, when we talk about the Indian polity section or polity, the first question that comes in our mind is that how a political system really works. You see, a political system of any country is based on the constitution. Whatever I will be writing it, आप इसको भी लिख लो. If I wish, तो मैं अलग से भी आपको लिखवाऊंगा. I'll make you to write it. And this will be your base. Wherever it is required that, okay, you can read some additional things, I'll tell you. Now, whenever we hear this word, constitution, what is the idea that we have in our mind? Now, whenever we talk about, we hear this word constitution, the first thing that comes in our mind that it is a document. What type of document? It is a document having special legal sanctity. We can also say that it is a legal document. Now, why we say that it has got special legal sanctity? It has got the sanction of law. And if an organization or if an individual will not follow the provisions of the constitution, the law will take its own course. You see, we have got an inquisitive mind, and if there is a document before us, then we feel to see that what is the content of that particular document. Suppose if the constitution is lying here, then we may feel to see that what is there inside the constitution. And when we turn the pages of the constitution, what we find? We find that it contains the principles and functions of the government of a state. So, principles and functions of what? Principles and functions of the government. Government of a state. So, here government and state. You see, this is your running notes. Some of you may have read the things mechanically earlier, but the UPSC requires an in-depth understanding. We call it as reading between the lines, not reading the lines, reading between the lines. So, because many of us are not from the PSIR background, we have not taken it as an optional paper also. Some of us may be reading the subject for the first time also, so that you can get an idea, you can appear in the examination and you will be able to answer the questions. So, we need to develop the understanding also. It should not be a mechanical class that only facts I will be telling. You see, if I use a term here, I will definitely explain it for the first timers. Some of you may be knowing it, it will be an advantage for you. Now, two words I have used here, government and state. Principles and functions of what? Of the government. Government of a state. Now, coming to some additional informations. Coming to some additional informations with respect to, we can say, this concept of state government. You see, when we talk about state, जो additional informations I will be telling you, आप क्या करना, you can write below it, or after writing you can just make a table that in what context the teacher was teaching, so that you will develop a good idea about it. Now, principles and functions of what? Principles and functions of the government. Government of what? The state. Now, when we talk about this concept of state, we'll stop here for a brief meeting. Ma'am will talk to you, then we'll continue.
So, good morning all of you. And I was listening to sir's approach. I found it so relevant. Sir was talking about how you should be preparing for prelims. So, all those who are going to give prelims, I think they should focus entirely on this particular course, because there cannot be any better way to revise this entire syllabus in a very limited time. The reason is you are doing from your side, but the experienced teachers, on the basis of their experience, they understand which topic to be studied in which way and how much weightage to be given to which topic. So, the experience has been, this course has been such that you don't have to do anything beyond it, but it is important to maintain the continuity. If you will break the continuity, because this is not a regular foundation course where you will be able to pick up the things, until and unless if you will be regular, because things will be done at a comparatively faster speed, because you have to cover the syllabus. So, what I suggest, don't miss the class, participate into it. Sir is a very experienced teacher, you are in safe hands. Sir will be covering the syllabus. In Polity, I will come and I will be doing PYQs, and through PYQs I will be sharing further notes with all of you. Fine. So, and once again wishing you all the best. Well begin is half done. Fine. And be positive. just because everyone, whosoever is going to give prelims, they are going to start from now. So the battle starts from now, and stay assured, in case there is any issue, do let me know anything. And even like with the teachers, if you find space is very fast, so it is always better, you can remind the teacher, they will do the things accordingly. Fine. So once your polity will be finished, sir will finish the entire polity, I will be doing the previous year questions, because I believe that's the best way to gain the confidence and understand where we stand. Okay. So thank you all of you. Yeah. Yeah.
So, we were discussing that the Constitution, it contains the principles and functions of the organs of the government of a state. Now, first of all, a term that has come before us is state. You see, the word state is used at different places in different contexts. In the Indian Constitution, the word state has been used first as units. Punjab, Haryana, Tamil Nadu, Sikkim, the states. Then, in the topic of fundamental rights and directive principles of state policy, the term state has been used to mean something different. That is, the union government, the state government, any authority of the government. But when we talk about state as a concept, as we use in political science, state is an entity having 4 elements. You can write state is an element, state is an entity having 4 elements. Population, territory, government, and sovereignty. Obviously, the people will be living in the state, that is population. Population of a state cannot be fixed. No doubt, some of the political philosophers fixed the population of the state. Plato fixed it to 5040. Then Aristotle also fixed it. Rousseau also fixed it, but for different reasons. But the population of the state cannot be fixed. But this population must reside within a fixed territory. Territory has to be fixed, otherwise there will be conflict. Then government and sovereignty. If we talk about population and territory, these are the physical basis of a state. You can see them. You can see that, okay, these are the people living, this is the territory of a state. Government is the political basis and sovereignty is the spiritual basis. You can feel it. You may be aware about population, territory, these are easier terms to understand. Government and sovereignty may be a bit technical also. Coming to this term sovereignty, sovereignty is the supreme decision making power. Now, in the individual context, if we talk about sovereignty, we all are sovereign over ourselves. What dresses we will be wearing, to whom we will be talking to, what type of food we will be having, we can take decisions regarding it. Over his mind, body and soul, an individual is free. That is, we can say sovereignty in the individual context. When we talk about a state enjoys two types of sovereignty. Internal and external. When we say internal sovereignty, laws of the state are binding on all the individuals and the organizations within the territory of the state. That is why you see, when an individual or an organization does not follow the laws of the land, then what we say? This group is challenging the sovereignty of the country. So, this is the concept of internal sovereignty. Now, when we say external sovereignty, the foreign relations are conducted without external pressure. We can say an independent foreign policy. Now, when we analyze this concept of sovereignty, you see that the units Tamil Nadu, Haryana, Punjab, they may have the population, territory, they may be enjoying internal sovereignty to some extent, but they do not enjoy external sovereignty. You may not have ever heard the foreign policy of Texas. It is the foreign policy of United States of America. So, internal sovereignty may be there. For example, if you go to the state of Bihar, there is prohibition. You will have to follow the laws which are there in Bihar. If you go to Tamil Nadu, you will have to follow some laws which are there in Tamil Nadu. But we have not heard about Tamil Nadu's foreign policy. So, this is what differentiates a unit from a state. So, in a layman's term, when we talk about a state, it will mean a country. It will mean a country. Now, you may be thinking that in polity, why we need to know this concept of state. You see, in one of the prelims examination, that was in 2021, a question was asked, which one of the following best defines the term state? So, that is what I told you in the beginning, that if you feel that Indian polity is only about mugging the articles of the constitution, then you will land up nowhere. So, there was a straightforward question, that which one of the following best defines the term state? And 4 options were there. You see, a community of persons permanently occupying a definite territory, a community of persons permanently occupying a definite territory, independent of external control, and possessing an organized government. So, if a student has understood this concept of state, definitely he would have answered this question in the examination. उसे तो 3, 4, जो second, third and fourth option पढ़ने की जरूरत ही नहीं थी. That is why in the class we start with the basics also, because the questions in the examination, they are asked from those basic things. The student generally feel, hey, what is the purpose of state? We need to know article 1, 2, 3, 4. So, we will compete in the examination. So, even such questions are asked in the examination. So, this is the concept of state. But yes, we will have to correlate the things. The themes are, the questions will be from the themes which will be discussed in the class, but the wordings will be different. That is the understanding that we need to have. Then, this was sovereignty, and you see the definition and the questions which can be asked. Then, when we talk about government, yes, you can feel it, you cannot see it. तो वो तो डिसीजन हो गया ना, वो तो गवर्नमेंट हो गया. वैसे इट इज नॉट ए पॉलिटिकल साइंस क्लास. आप लगता है पॉलिटिकल साइंस ऑप्शनल के हो, इसलिए लिख भी नहीं रहे हो कुछ, तो बॉडी लैंग्वेज से ही पता चल गया. मैडम से पूछ लेना क्लास में, ठीक है. यहाँ पे जीएस और वो भी प्रीलिम्स, क्वालिटी एनरिचमेंट प्रोग्राम, यहाँ पे पूरी पॉलिटिकल साइंस पढ़ने के लिए वी आर नॉट सिटिंग. ये मेंटेन रखो, ठीक है. ये चीज हमेशा ध्यान रखना कि इट इज नॉट ए पॉलिटिकल साइंस क्लास. इसीलिए it is not always that the student reading PSIR will be very good in Indian polity. More reading, more confusion. Less reading, less confusion. That does not mean no reading, no confusion. Yes, PSIR optional पढ़ते हो, इसका मतलब नहीं कि पॉलिटी में सर पूरा PSIR पढ़ा देंगे. हाँ, we have a different platform for it and we'll charge you fees for all that. फ्री में उतना नहीं होगा. हाँ, घबराओ नहीं. We are very professional persons. ये नहीं पहली बार तुम्हें बैठ के पढ़ा रहा हूं. Yes. Coming to the aspect that I was talking to you. It is government. Now, if you are asked, what is a government? Then, basically, when we talk about government, the idea of the executive comes in our mind, and that too the political executive, the NDA government or the UPA government, the BJP government, the Congress government, that comes in our mind. But when we talk about the government, if we need to define the government, you see, every state performs three functions for its people. It makes law, that is law making. Second, law implementation. And third, law adjudication. These three functions are performed by an agency called the government. So, on behalf of the state, who makes law? It is the government. And no doubt in your country you will say that the parliament has made this law or the state legislature has made this law. But in the foreign media, what they say, India has made a law which is being opposed by some sections of the society. India has made a law. The name is that of the country. Similarly, law implementation. We all know that this is a function of the police, of the civil servants, but outside India, what is said? India violated the human rights. Sudan violated human rights. Sri Lanka violated human rights. The name is that of the country. Even though a particular agency within the state violates it. And we all know law adjudication is the work of the courts. But what is said outside? Oh, that country, it never imparts justice to the people. The name is that of the country, the state. That is why we say that these three are the functions of the state. And on behalf of the state, it is the government which perform these functions. So, in a nutshell, if you are asked that what is a government, you have read so much of political science, so much of polity for preparing for the civil service examination. So, our answer will be that government is a machinery through which the laws are made, implemented, and adjudicated. Or we can also say that government is an agent of the state. An agent of the state. So, on behalf of the state, it is the government which performs these functions. You see, there is a minimum knowledge that is required for a civil services aspirant. Minimum knowledge. And as a citizen also, we need to have minimum knowledge of certain things. You people are also preparing for the civil service examination. You have, the society expects a lot from you. Even your siblings who may be reading in class 5th, class 6th, class 7th or class 8, they, acha, my didi, my brother, my uncle preparing for civil service examination. And if they will come with a book, civics book, uncle, mama, bhaiya, what is this government? So you are not supposed to tell them, hey, UPA government, Congress government, no. Yeah. You need to, yes, that will reflect your personality also, your understanding also. That should be a spark in you. that yes, I am preparing for the civil service examination, I have got an understanding of the things. I will not just mug up and crack the examination. So you should tell the kid that, dear, you know, a country, a state has got 3 functions to perform, and you will tell him about the 3 or her about the 3 functions. And these 3 functions are performed by 3 different organs, and combinedly that is known as the government. So government is an agency through which the various functions of the state, law making, law implementation and law adjudication are performed. अभी बताओ, इसमें there is no need to mug up. You'll have to develop an understanding so that you can make the other person understand the things. अभी students में क्या, they just try to mug up the things. So, but you need to understand it in your mother tongue so that you will be able to let the others understand your point of view. Now, these 3, I said law making, law implementation and law adjudication. So, these 3 functions are performed by the government, and these 3 specific functions are performed by 3 different organs. The task or the function of lawmaking is performed by the legislature. Law implementation by the executive, and law adjudication by judiciary. Many of you may be aware that across the globe we have got 2 types of legislatures. In some of the countries we have unicameral legislature, means only one house. In some of the states we have bicameral legislatures, 2 houses of the legislature. Then when we talk about the executive, here also in the countries what we have seen is that we have got the temporary executive and permanent executives. The ministers are the temporary executive, and the civil servants are the permanent executives. Now you see, whenever we talk about these 2 types of executive, we need to understand one more thing. The term of the ministers is not fixed. Nowhere you will find it is mentioned that the minister has to be for 5 years or 4 years. And the ministers come and go. You see, in the last Lok Sabha, Shri Rajnath Singh was the Home Minister. In this Lok Sabha, he is the Defense Minister. So then in this Lok Sabha also you may have seen the change of ministries. Sri Kiran Rijiju was once appointed as the Law Minister. Then that post was, the ministership was taken and it was given, this portfolio was given to another minister. So the ministers come and go. On the other hand, when we talk about the permanent executive, the civil servants, they are in that ministry. They are aware about the continuity of the different policies and programs, and they are there to assist the ministers in understanding the complexities, the policies which are going on in the ministry. Another thing, the ministers, they have got farsightedness. Why? Because they have been elected by the people, they feel the pulse of the people. That is why the people have elected them as their representatives, because the people feel that this set of people, by following a particular ideology, will be able to solve their problem. They will be using the taxpayers' money judiciously. And then how that money, taxpayers' money, will be utilized, these persons may not be an expert in that. Because of the nature of the examination and the training that the civil servants undergo, they develop the skill of law making and law implementation. Both have to work together. That is why we have the concept, one elected, other appointed. So that is why, so both have to work together. Both have to work together. Then judiciary, the courts. Now, if we talk about the constitution of any country, say it America or Germany or France, the constitutions talk about these organs of the government: legislature, executive and judiciary. And that is why you see their powers have been defined, they have been delimited. That is what we started with. It contains the principles and functions of the organs. The three organs that I told you of the government of a state. 3 words I told you, 3 words I defined. And from here, they will not be asking you a question that define the constitution. So one question we discussed related to the state. Then the second question can be with respect to the UPSC is very fond of asking this question, that which of the following statement is correct. So here you can write as note, the objective of the constitution, objective of a constitution is to provide a limited government, is to provide a limited government, that is the powers of the government are restricted by the provisions of the constitution. Now, if you see the questions which have been asked in the previous years, in the prelims examination, every alternate year, you can find a question related to it. Which of the following is correct? This statement can be there, limited government. Then in 1 year, another question can be there. The statement will be, the constitution puts restrictions on the rights of the people. The constitution puts restrictions on the organs of the government or the powers of the government. So it put restrictions on the organs of the government. Then there can be another term, constitutionalism. It is not a big term. So the object here is also limited government. So the things are correlated. The things are correlated. The words can be different, but the theme is one, limited government. So you see, from the very first aspect, the UPSC always asks questions. Your understanding of the constitution. The definition of the constitution will not be asked, but you have got an understanding, then you will be able to answer these questions. And in the examination, the students generally, they should not, but they feel that these questions are difficult questions. But these questions may not prove to be difficult for us. So this was your idea about, we can say, the constitution, the purpose of the constitution. You see, in the year 2021, there was a question, constitutional government means. The four options were a representative government of a nation with a federal structure, a government whose head enjoys nominal powers, a government which enjoys real powers, and a government limited by the terms of the Constitution. So, a government limited by the terms of the Constitution. So, in the year 2021, one question was there on constitutional government, one question was there on the state, that is the definition of the state. Then you see in 2020 also, there was a question, a constitutional government by definition is a, and the fourth option was limited government. So, in 2020, that is what I said, the trends show. What the trends show? So, you need to have an understanding about the Constitution. Then in 2014, way back, a constitutional government is one, and the question was on the constitutional government. So, here also it is a restricted government, it is a limited government. Now, this was the first basic thing that we need to know. Now, before we proceed further, there is another basic thing that we need to know in the Indian polity section. It is the types of majority under the Constitution. Majority is the number required to get a resolution passed or a bill passed in the legislature, the number required. Depending on situations, we have got different type of majorities mentioned in the Constitution. The first type of majority is simple majority. Simple majority is more than 50% of the members present and voting. Present and voting. More than 50% of the members present and voting. For example, suppose in the Lok Sabha, we have a strength of 543 members, and out of these 543 members, all the members are not present daily. Suppose on a particular day, 500 members are present in the house. Out of the 500 members, it is not necessary that all should take part in the voting. Suppose during the voting on a particular bill, 40 of the members, they did not take part in the voting. That is known as abstention. You are present in the house, but you are not voting. That is abstain. So suppose 40 members abstain. So present and voting will be 460. And simple majority here will be 460 divided by 2 plus 1. It is more than 50% of the members present and voting. This is the concept of simple majority. For those who may not have understood it, I'll give you another example so that you can correlate. Suppose the strength of the class is of 150 students. Suppose 100 of you are present today, and if I ask you a question that how many of you want a break tomorrow, it is a hypothetical question, there will be a class tomorrow. So if I ask you that how many of you want a break tomorrow, 20 of you will say, sir, we will not take part in such type of voting, and if there will be class, we will come, otherwise we will also take rest. So 20 of you, what you did? You abstained. You are present in the class, but you did not take part in the voting. That is abstain. So how many of you are present as well as voting in the class? 80. What will be the simple majority here? Very good. So this is the understanding that we need to have, because in the newspapers, if you read, it was passed by a simple majority. And if you don't know what is a simple majority, you will never be able to understand the newspapers also. Now, you can write here as note, N-O-T-E. Wherever the constitution is silent, wherever the constitution is silent, on the type of majority required, on the type of majority required, it is assumed that simple majority is required. It is assumed that simple majority is required. Because in the coming classes, I will be using these terms. If I discuss with you a bill or a motion in the parliament, I'll be telling you, okay, simple majority will be required, so that you will be able to connect. So, okay, this is the simple majority. So, I'll not have to repeat it again and again. Now, in the constitution, wherever it is mentioned that it has to be passed by the house, it has to be passed by the house, then it will mean that simple majority will be required. There you will not say where it is written that simple majority is required. It is not mentioned. That is why simple majority will be required. That is a common sensual thing. Because for all other purposes, wherever there is required special majority, the majority has been mentioned in the constitution. This majority is the easiest majority required under the constitution. It is also known as working majority. It is also known as working majority. काम चलाओ बहुमत बोलते हैं. That is working majority. This is the first type of majority. Then, coming to the second type of majority, it is absolute majority. It is more than 50% of the total membership of the house It is also termed as majority of the house or majority of the whole house. For example, in the Lok Sabha, it is fixed 272. It is more than 50% of 543. more than 50%. In the Delhi Legislative Assembly, (70) divided by 2 plus 1. In the Rajasthan Legislative Assembly, it will be 200 divided by 2 plus 1. 200 is the total strength, total membership of the Rajasthan Assembly. 70 is the strength of Delhi Legislative Assembly. In Sikkim Legislative Assembly, this will be 32 divided by 2 plus 1, because the strength of Sikkim Legislative Assembly is 32. Now the question that can be there in your mind, that sir, where this majority is needed? This majority is needed for the formation of a government. You see, in Rajasthan, which political party formed the government? The party which had got more than 50% of the seats in the Rajasthan Legislative Assembly. Which political party formed the government in Telangana? The party which has got more than 50% of the seats in the Telangana Legislative Assembly. Then which party is ruling at the center? It is the coalition, that is the NDA. NDA has got more than 50% of the seats in the Lok Sabha. In the coming Lok Sabha elections, that is, which is going to be held in the month of May or June, the party which will get 272 seats, that political party will form the government. This is the basic understanding. That is, this majority is required in case for the formation of a government. What we say? That party has got majority. So when we say that party has got majority, it means more than 50% of the total strength of the house. This is the basic understanding. Then coming to the third type of majority, it is effective majority. It is more than 50% of the effective or the then strength of the house in case of absolute majority. What we had written, more than 50% of the strength of the house. Here it is more than 50% of the effective or the then strength of the house. When we say effective or the then strength, effective strength or the then strength, it is a strength of the house minus the vacancies. Here vacancies will not be counted. For example, suppose Rajya Sabha. The strength of the Rajya Sabha is 245, and suppose if 2 members are dead, 3 members have resigned, These are the vacant seats. These are the vacancies. 5 seats are vacant here. So here the effective strength or the then strength will be 240. The majority required here will be 240 divided by 2 plus 1. This will be the majority required. So here we will not be taking into consideration the vacancies which are there. इसे count नहीं करेंगे. Vacancies will not be counted here. Here this number will be counted. हाँ, यहाँ पे it is not present and voting. 240 means it is the effective strength. More than 50% of 240. So because if here you will be counting present and voting, it will become a simple majority. So here whether you are present, absent, it hardly matters. We will be requiring more than 50% of this number. It is known as effective majority. You will also find the expression majority of all the then members of the house. Different expressions are there. Majority of all the then members of the house. All the then members. ये तो हुआ your basic understanding for the students who are reading this subject for the first time, and the thing should not be mechanical for you. Now the question from here, where this majority is required. So you're right, this majority is required. This majority is required first in the Rajya Sabha for the passage of resolution for the removal of the vice president. This will be discussing again all the aspects. That is, when we are discussing the vice president, how the vice president is removed. But yes, since we are discussing the majority, you need to have an idea also. Suppose Shri Jagdeep Dhankar is to be removed, then the resolution for his removal will be introduced only in the Rajya Sabha. It cannot be introduced in the Lok Sabha. And then the Rajya Sabha will have to pass the resolution by this majority. That is, by the majority of then members of the house. That is more than 50% of the effective strength of the house. After that, it has to be approved by the Lok Sabha by a simple majority. That is why we have not used the term parliament here. We have used the word Rajya Sabha. In the Rajya Sabha, effective majority will be required for the passage of resolution for the removal of the vice president. Then, secondly, in the concerned legislatures for the passage of resolution for removal of their presiding officers when we say presiding officers, in the case of the Lok Sabha and state legislative assemblies, the speaker and deputy speaker in the case of the Rajya Sabha and the legislative councils, the presiding officers are the chairman and deputy chairman. Most recently, we had seen the motion in the resolution passed in the state of Bihar to remove the speaker of the Bihar Legislative Assembly. So, the resolution which was introduced in the Bihar Legislative Assembly for the removal of the speaker was to be passed by this majority. If the speaker of the Kerala Legislative Assembly is to be removed, this majority will be required in the Kerala Legislative Assembly. If the speaker or deputy speaker of the Lok Sabha is to be removed, then this majority will be required in the Lok. So your keyword will be the then strength of the house, or the cover term is effective majority. In the constitution, the expressions simple majority, effective majority, absolute majority, these have not been mentioned. So where it is written to be passed by the house, it means simple majority. Where it is mentioned majority of the, we can say, whole house, so it will be, whole house means it will be the absolute majority. So first simple majority, so it has to be passed by the house, it has to be passed by the house, simple majority. Then passed by a majority of the house or whole house, it will be absolute majority. And the third will be this one, majority of all the then members of your common sensual thing, wherever it is related to the presiding officers only, not in any other case. The effective majority will be required only in case of presiding officer. And as the vice president is the presiding officer of the Rajya Sabha, that is why the resolution is introduced in the Rajya Sabha and effective majority is required in the Rajya Sabha. So common sense क्या हमारा बोलेगा? That is, if the presiding officer is to be removed, what will be your keyword? Majority of the then member. Then will be your keyword here. Such type of keywords you need to catch. That will help, because it is not possible on our part to mug up each and everything. You will have to take some keywords. Then, यहाँ तक समझ में आ गई? हाँ, the things are clear to all of us. Now coming to the fourth type of majority. It is special majority. Special majority is used as a cover term. It is used as a cover term. People say special majority is required. But from today, those who are reading the subject for the first time, for you, there are three types of special majority. So a smart one will ask you, which type of special majority? So here three types of special majority used under three different circumstances. First, not less than 2/3 of the members present and voting. Not less than 2/3. So even 2/3 will also do. For example, suppose in the Rajya Sabha, we have a strength of 245 members. Out of that, 230 members are present and voting. So the majority required here will be 2/3 of 230. Here 2/3 will also do. Earlier it was more than 50%, that is why we had written +1. So here 2/3 will also do. This majority is separately used at two places. Those conditions I will tell you when we will be discussing the parliament. And I will tell you at that point of time that we had discussed it in the very first class. I will remind you also. So because today is our first class, some of you may be reading it for the purpose of revision. Some of you may be the first timers, and for the first timers, there may be bouncers also. So you'll have to take care that first of all some basics have to be cleared. Otherwise, there will be bouncer also. Arey, ho kya raha hai? So till the time we'll reach the discussion on parliament, yes, the momentum will be there. You will be able to understand in what sense I tell many things. So I will remind you at that point of time also. So this I will tell you that where this majority is used separately. Then coming to the second type of special majority, here two conditions have to be fulfilled. Two conditions have to be fulfilled, not one. First, more than 50% of the total membership of the House that is absolute majority and secondly not less than 2/3 of the members present and voting. Both the conditions have to be fulfilled. It is not either or. Both the conditions have to be fulfilled. For example, suppose a bill has been introduced in the Lok Sabha or a resolution is introduced in the Rajya Sabha or Lok Sabha which needs this majority. So, a case in the Lok Sabha where we require this majority. Suppose 450 students, or we can say the members are present and voting. 450 are present and voting. Now, both the conditions have to be fulfilled. Absolute majority is fixed. Here, it will be 272. Now, this number is mandatory. 272 is the minimum number that will be required in the Lok Sabha. for passing of such type of bills. Along with it, not less than 2/3 of the members present and voting. What will be the 2/3 of 450? कितना होगा? You will have to appear in the CSET also. 300. Okay. CSET is also important. वो ध्यान रखना. So, if we talk about 300 mark, I'll give you a hypothetical situation. Suppose if 299 or 298 members vote in favor of the bill which requires this majority, if the bill will be passed or not. No. Why? This condition is being fulfilled, but 298 is not the 2/3 of 450. Both the conditions have to be fulfilled. If it is 300 or more than 300, then both the conditions are being fulfilled. Now coming to the flip side of it. Suppose 400 members are present and voting. What will be the 2/3 of 400? 267. देखो, I am very poor in maths. That is why after 10th I did not read maths. If it is a correct answer, because the company will not be responsible for any wrong answer. I have asked you, you told me 267, I have written it. I will not be responsible. So, 267. Now, a hypothetical situation. Suppose if 270 members are voting in favor of the bill, which requires this majority, if the bill will be passed or not. No. No doubt 270 is more than the 2/3. So, this condition is being fulfilled, but it is not the absolute majority. It is a tough majority. Minimum 272. And I will give you a hypothetical situation. For example, if 272 members are present in the Lok Sabha on that particular day, how many members must vote in favor of the bill? All. 100% voting. So, it is a tough majority. So, it must be in use for some tough work. So, where this majority is required? This majority is required for, first, under Article 368 for the passage of a constitution amendment bill in both houses of the parliament. No joint sitting. Lok Sabha, Rajya Sabha sitting separately, they should pass the bill by this majority. Then, for the passage of resolution in both houses of the parliament for the removal of the judges of the Supreme Court and High Courts, the CAG, Chief Election Commissioner, and the State Election Commissioners. So here you see that these constitutional officers are to be removed by the president only after a resolution is passed by both the houses of the parliament sitting separately by this special majority. And third, in a state legislative assembly, for the passage of a resolution requesting the parliament to create a legislative council for the state. A legislative council for the state. How many of you belong to the states which have got legislative councils? Okay. Others, you don't have a legislative council? Okay. I'll create for one of the states. You tell me which state you want? You want Bihar में है? कितनी बार बनाओगे? You want it for Jharkhand? You are from Jharkhand? Okay. वेस्ट बंगाल में बना दें? नहीं, वहां बिना परमिशन के दिक्कत है. चलो ठीक, ओके. आराम से आराम से. यूपीएससी का एग्जाम दे रहे हो ना? हाँ, तो फिर if you will be in the class, if you will be there in the meeting, you are a DIG and the CM is taking a meeting and you will talk rubbish, then भूल जाओ. हाँ, there देखो, administrative aptitude has to be there. It is not that you will become an IAS officer. Oh, I am so arrogant. It's not like that. You need to know how to sit in the class, what to speak. You need, that is the difference is, that is why only 1,000 of you will get selected out of 6 lakhs who will appear. So that has to be maintained. If you speak rubbish, Bangladesh, sorry, what is it? Yeah, this is not expected from a UPSC aspirant. यही चीज दूसरे लोग बोलेंगे यूट्यूबर टीचर्स, अब बोलेंगे वाह सर क्या बोलते हैं, ये मैं बोल रहा हूं, तुमको लगेगा बेवकूफ है. समझ गए ना यार? यू नीड टू बिहेव प्रॉपरली. आप लोग आईएएस बनोगे, मुझे क्या है, मुझे तो जितने पैसे मिलने उतने मिलेंगे. यस, सो ये हमेशा ध्यान रखना that you are sitting here to become a civil servant. How you sit, how you speak, your words reflect your personality, and in the interview board you will not be able to develop that personality in one day. It is a process that goes on. So that, and in this class you need to learn all these things. तो हम लोगों ने commercialization कर दिया, coaching center है, we give fees, whatever, we will sit in the class or not. We'll sit like a jamindar in the class. How to sit in the class, how to enter the class, how you need to talk to your friends, everything will matter. That is a complete IAS personality. That should be reflected in you. Now, I will not be biased towards one state or the other. I will not create the legislative council for the states that you have demanded for. Madhya Pradesh. How many of you are from Madhya Pradesh in the class? The two of you are very silent. So let us create a legislative council for Madhya Pradesh. So if we want to create a legislative council for Madhya Pradesh, then first of all, the Madhya Pradesh Legislative Assembly to pass a resolution. To pass a resolution by a majority of the House and by a majority of not less than 2/3 of the members present and voting, requesting the Parliament to create a legislative council for the state. So the initiative has to be from the Legislative Assembly, and the Legislative Assembly will pass the resolution by this majority. And after that, the Parliament, by a simple majority, will pass the bill and a legislative council will be created. The same is the process for the abolition of the legislative council also. For example, if Uttar Pradesh or Maharashtra want to abolish the legislative council, so at that point of time, an initiative has to be taken by the legislative assembly of the state. I will repeat these things again when I will be discussing the state legislature with you. So, अभी अगर थोड़ा बहुत कम भी समझ में आ रहा है, you should not be, we can say, unhappy about it. So when we will be doing the class, मैं दोबारा फिर आपको I will make the things repeated in the class. So how a legislative council will be created? Created by the Parliament on the request of the state legislative assembly. That is the key word that you need to remember. Then coming to the third type of special majority. Yes? Sure. Yes. Yes, yes, yes. Andhra Pradesh State Legislative Assembly has already passed a resolution way back for the abolition of the Legislative Council, but it has not been abolished by the Parliament yet. Not only this, Gujarat and Odisha are the states which had already requested for it before the pandemic only, but it has, we can say, the request has not been, we can say, ceded by the Parliament. It completely depends on the Parliament. Your work, means the work of the assembly is to take the initiative only. Done? Now coming to the third type of special majority, it is under Article 61. Impeachment of the President. The majority required here is not less than 2/3 of the total membership or a strength of the House. When we say House, means Lok Sabha, Rajya Sabha. separately. So it is also fixed. In the Lok Sabha, it will be 2/3 of 543. In the Rajya Sabha, it is 2/3 of 245. There is another clarification that I will like to give you with respect to this word impeachment. Constitutionally, the word impeachment has been used only for the President of India. तो बाद में I may forget also. That is why I am telling you this now only. But in the loose terms, we have seen the use of the word impeachment even for the judges of the Supreme Court as well as the High Courts also. Even in one of the question papers of the UPSC, the word impeachment was there. Now, if you are asked that what is the difference between impeachment and removal, you say, what I said, constitutionally, the word impeachment has been used only for the President of India. Impeachment is a special legislative process. It is not a normal legislative process. It is a special legislative process. And as soon as the resolution will be passed by both the houses sitting separately, automatically the President gets impeached, automatically. But when we say removal, removal is an executive action. What our Constitution says, a judge of the Supreme Court to be removed by the President. When the President will remove? Upon the passage of a resolution by the houses of the Parliament by a majority of not less than 2/3 of the members present and voting, and by the majority of the House, or we can say not more than or we can say more than 50% total membership of the House, on the grounds of proved misbehavior or incapacity, removed by the President. So after both the houses of the Parliament will pass the resolution, then only the President can remove the judge. So it is removal. Now, there can be a question in your mind, then why even in the loose terms, the word impeachment is used for the judges of the Supreme Court? Even the Supreme Court uses this term, impeachment of the judges. It is in the context. In social sciences, text is important, context is also very important. It is in the context. What is the context here? The power that the Parliament enjoys in the removal of the judges. Until and unless the Parliament will not pass the resolution by special majority, the President cannot remove the judge. And the ground is also different, even the majority is also different. So it is in the context. So if someone will ask you that why the word impeachment even in the loose term is used for the judges, you should say that it is in the context, because it is completely dependent on the Parliament. Until and unless the Parliament will not pass the resolution by the special majority, the President cannot remove a judge. So the context has to be understood. Lekin in the prelims examination, constitutionally the word impeachment has been used only for the President of India. Rest all are removed. This was the basic knowledge regarding the types of majority in the Indian Constitution. Now, coming to the next aspect, salient features of the Indian Constitution. No, because that is not a special process. There is no special majority required. Effective majority is required in the Rajya Sabha. Simple majority is required in the Lok Sabha. But basically what we have seen is that the word removal has been used in the constitution, and impeachment is a special legislative process. We need a special majority in both the houses for that purpose, which is absent in the case of the vice president. He is removed basically as the presiding officer. As he is the vice president, simple majority is required in the Lok Sabha. Now, here there are two approaches. One, the one-day examination approach, that will not be going through. Lengthiest constitution. Then, in our prelim syllabus, there is a topic called political system. And in your main examination, there is a topic called the comparison of the Indian constitution with the other constitutions. So we'll have to correlate the things. देखो, जब तक mains अच्छे से नहीं पढ़ोगे, you will not be able to appear in the prelims examination also. That is why a touch is being given. The syllabus is correlated. Now, here I have taken some topics from the prelims point of view, from where the questions can be expected. When we talk about the salient features, first is that the Indian constitution is a written constitution. Now here only we will compare. In some of the countries, they have unwritten constitutions. Now one by one, question will, which one of the following is a feature of a written constitution? Which one of the following is not a feature of the written constitution? Such type of questions may be expected in the prelims examination. Now here you can write first, a written constitution is that constitution the provisions of which have been codified. The provisions of which have been codified. What is codification? Codification is systematic arrangement of the different provisions. लिख लो. Codification means systematic arrangement of the provisions in a document, in a single document. Now, on the other hand, if we talk about an unwritten constitution, here you can write, an unwritten constitution does not mean that the provisions have not been written down. I repeat, an unwritten constitution does not mean that the provisions have not been written down, but are not codified, or systematically arranged, Here, if we talk about a written constitution, the US Constitution, the Chinese Constitution, the Indian Constitution, the French Constitution can be termed as written constitution. On the other hand, if we talk about an unwritten constitution, the UK Constitution, the Constitution of New Zealand can be termed as unwritten constitution. Now, if we talk about the UK constitution, it does not mean that the provisions have not been written down, but you will not find all the provisions in a single document. There are different statutes. Statutes means the laws made by the parliament. So, one statute will be dealing with the parliamentary laws, one statute the Judicial Act, one statute the writ of habeas corpus, one statute regarding the Bill of Rights. At one place you will not find everything, but and you will cannot say that this document is the Constitution of United Kingdom, this document is the Constitution of New Zealand. On the other hand, here you can say that this document is the Constitution of United States of America, this document is the Constitution of India. And if we talk about these constitutions, the provisions related to the legislature, executive, judiciary, they are in one book. In case of India also, if you see, the provisions regarding the creation of new state, citizenship, rights of the people, what are the duties of the state towards the people, that is directive principles of state policy, then the provisions regarding the governments at the union level and at the state level, local self-government, center-state relations, all have been written in one book. That is, we can say, codified. Then, apart from it, if we talk about a written constitution, it is an enacted constitution. A group of people sat together, they wrote the constitution, and then they said, this is the Constitution of United States of America, this is the Constitution of India, this is the Constitution of France, an enacted constitution. On the other hand, if we talk about an unwritten constitution, it is mostly an evolved constitution. Gradual evolution. A group of people never sat down and wrote all the provisions at the same time. Gradual evolution. For example, if we talk about the Constitution of UK, the UK Constitution has been evolving since 1215 AD, that is the time of Magna Carta. Some laws which were there in 1215 AD, they are still present in United Kingdom. And if a new law is required, the Parliament, by a very ordinary process, makes another law. It is not that a group of people sat together and said, this is the Constitution of United Kingdom, and you can make laws according to that. Nothing. In case of United States of America, it was the Philadelphia Convention. In case of India, it was the Constituent Assembly. No doubt, evolution is a part of every constitution. That is a part. In our constitution also the things are evolving, but within the constitution itself, the Constituent Assembly, through the constitution, has empowered the Parliament to make changes in the constitution according to the changing times and circumstances. But technically speaking, the word enacted and evolution is used in that sense. Otherwise, you can also say that, sir, Indian constitution is also evolving. So, basically, it is in the context. And the most important difference is, in a written constitution, there is supremacy of the constitution. Why there is supremacy of the constitution? Here we can write as note, the three organs of the government owe their origin and derive their authority from the Constitution. Reasoning assertion question. In India, there is supremacy of the Constitution. Reasoning, all the organs of the government owe their origin and derive their authority from the Constitution. Then, when we talk about an unwritten Constitution, here there is parliamentary supremacy. In India, the parliament was provided for by the Constituent Assembly. The Constitution talks about it, that the parliament shall consist of. These will be the powers of the parliament. On these subjects, the parliament can make laws. So the parliament itself did not decide that on what topics will be making laws. The Constitution authorizes the parliament. When we talk about an unwritten Constitution, there was nothing called the Constituent Assembly. It is the parliament itself which decided that we will be making laws on these aspects. We will change the process, the provisions of the Constitution by this process. It is the parliament which decided. The British Parliament is supreme in the sense that the British Parliament can make laws on each and every subject. And not only this, the laws of the British Parliament cannot be challenged before any authority and it cannot be declared as void or invalid. According to some commentators who have commented on the supremacy of the British Parliament, because in an unwritten constitution the commentaries are also very important. So some of the scholars, they have commented that the British Parliament is so powerful that it can make laws on any subject except on changing a man into a woman and a woman into a man. Means whatever is naturally possible on those subjects, the Parliament can make laws. This is the supremacy of the British Parliament. Such type of questions are asked in the main examination also. In the last main examination, there was a question related to it in the GS paper. The sovereignty of the British Parliament vis-a-vis the Indian Parliament. In India, there is supremacy of the Constitution. The Parliament will have to make laws in accordance with the provisions of the Constitution, and not only in accordance with the provisions of the Constitution, but in accordance with the process which has been mentioned in the Constitution. And not only the provisions of the Constitution, the Parliament will have to make laws by living within the limits of the Constitution. It cannot go beyond the basic spirit of the Constitution that has been termed as the basic structure. So limitation is there. Such questions are important from the prelims point of view. This is the most important point. In an unwritten constitution, there is parliamentary supremacy. And in case of a written constitution, there is constitutional supremacy. And here, such type of questions will be there in the reasoning assertion portion. So you need to remember like this. छोटे topics हैं, you can pick them. Okay, what questions can be asked from here? Then it will be pre-oriented preparation. Otherwise, you will go here and there. Okay, this aspect, such questions can be asked. Your work is over. Then, coming to the next aspect,
Every law of the British Parliament is included in the Constitution.
No, they have got a separate statute. For example, if they make a law on judiciary, then the law it will be in a separate book. For example, if they make laws related to judiciary, they have got Judicial Act. So the provisions can be incorporated in the Judicial Act. Here we are talking about the Constitution in the sense that in one document all the provisions will be there. So there they have got acts, different books are there in which different laws are there. At one point of time, at one place you will not find every law.
What will you say is the composition of the book? For example, it's not one at one place.
That is what I said. That does not mean that things have not been written down. They have not been compiled together. They have not been codified. They have not been systematic. The same thing I was also saying.
Every law will be in the Constitution, in the composition of the Constitution.
For that you will have to study the British system. In Great Britain, or obviously where we have got unwritten constitution, and even where we have got parliamentary system, there are laws, statutes we call them. Then conventions are also there, which are as important as the laws. Then there are commentaries of the eminent scholars. That is, what should be the relationship between the cabinet and the government or the parliament, such type of thing. And then basically the common laws are also there. A law which is made by the legislature will be mentioned in the statutes. Will be mentioned in the statutes. क्योंकि वो verbal नहीं है कि चलो आप कहीं तो लिखोगे ना, somewhere you will have to write it. So obviously a law made by the legislature obviously will be mentioned in the law books. And some conventions are also there. In our country also we have got some conventions. When we are discussing the parliament, I will be telling you about the parliamentary conventions that we have in India. When I will be discussing the Council of Ministers, I will be telling you about what conventions we follow with respect to the Council of Ministers. Now, coming to another feature of the, तो यहां से ये क्वेश्चन ऐसे ही पढ़ना है, ठीक है? अच्छा, no, basically when we say evolving document, obviously that is what I said, that the evolution is the real, change is the only unchanging reality of this world. So according to the times and circumstances, basically what the thing is that your constitution has to be evolving. So if it is evolving constitution, then obviously that will be a correct statement. Evolved constitution, no, it is an enacted constitution. Yes, it is evolving with the times and circumstances. Earlier you said, you see, we don't have the provisions regarding to local self-government. Now we have got a provision regarding the local self-government. Earlier there was no provision with respect to reservation for women in the Legislative Assembly and in the Lok Sabha. Now we have mentioned it. It is evolving, but it is within the limits of the constitution. The process, that how the changes will be made, the process has been mentioned in the constitution, which is missing in the English constitution. That is the basic difference. Now, coming to the second feature of the Indian constitution, it has been drawn from various sources. When we say it has been drawn from various sources, the critics, they say that the Indian constitution is a bag of borrowings. As a student of politics, I have got strong reservation for this term, bag of borrowings. Two things are there. One, no constitution can claim originality. Even the first written constitution of the modern times, that is the American Constitution, cannot claim originality. It was not that the members who were sitting in the Philadelphia Convention, they had everything in their mind and they wrote, the president will be elected in this manner, will have such type of, it's not like that. The ideas must have been taken from the political philosophers and the political scientists. It cannot be original. And so that is one thing. No constitution in the world can claim originality. And with respect to the Indian constitution, Dr. Ambedkar himself had said that we are enacting this constitution at this point of time when nothing can be original. When nothing can be original. Then when we say borrowing, if you borrow something, you will have to return it. You will have to return it. So, and constitution is not the copyright of any country. You write the constitution, see, it is not the copyright. So that is why I have given a better nomenclature drawn from various sources. It is just like a shirt. If you are wearing a shirt and if I like that shirt, I will go to the shop and I will purchase the same shirt, the same brand, the same style, but what will be the difference? What will be the difference? The shirt size. The shirt size will be different. According to my needs, I will take the size that fits me. So no doubt, our constitution makers, they went through all the constitutions which were prevailing at that point of time. But what they did? They took different aspects from different constitutions, but they gave them an Indian color. For example, if you talk about this concept of federalism, just an example here. This concept of federalism, dual sets of government, one at the central level, other one at the state level. People say that we have taken federalism from United States of America. Yes, the idea that there should be two sets of government, it has been taken from the Government of India Act 1935. The idea of federalism, not federalism, idea of federalism. Because if you have read history, you may have read that under the Government of India Act 1935, there was provision for elections to the provincial assemblies also. So, we were aware, central government at London, then we have got the provincial governments. Our constitution makers did not follow the American model. In America, dual constitution, dual citizenship. In our country, it is not the case. So how can you say that federalism has been taken from America? Our constitution is basically based on the Canadian constitution. Why? When our constitution makers were enacting the constitution, they had in mind the diversity of India. And if we would have followed the American model, then our country may have disintegrated. That is why our constitution makers started searching for a model which provides for incorporating the plurality of the society. Canada was such a country, a multicultural society. Our society is a plural society. So, in Canada, they have adopted a concept of federation with a strong center. So, this concept of federation with a strong center we have taken from Canada or Canadian Constitution. I am just giving an idea that you should not be the simple followers of a book. In that book it is written bag of borrowings. I will say, sir, it is bag of borrowings. And After that, we did not stop here. Our constitution makers thought of the future problems, that there may be disputes between the states. How that interstate disputes, the center state disputes, can be solved amicably without going to the court. No doubt, it is a typical thing. The federal court is always there. That is why when our constitution makers were searching such a model, they got this a special model called the concept of cooperative federalism from the Australian constitution. So, the concept of cooperative federalism we took from Australia or the Australian constitution. So, how can you say that Indian constitution is completely a bag of borrowings? So, if such questions are asked in the main examination, that is how far the Indian constitution can be termed as bag of borrowings, how far it can be termed as a bag of borrowings. What the students generally do, they write about the sources of the constitution, that from here we have taken this, और last में लिख देते हैं, that is, it is a bag of borrowings. इसीलिए they get lesser marks in the polity part also, and in the PSIR, Indian government and polity, because they feel, what, we can write anything. Here we'll have to analyze. And first of all, this part I gave you illustration that no doubt we have taken different aspects, but we have given them an Indian color. Some of the aspects we have taken from the other constitutions and we have incorporated in the constitution without any change. That is also there. Article 301, freedom of interstate trade, commerce and intercourse. We have taken from Australia and we have mentioned in our constitution without any change. Some of the aspects are our own. We have not taken it from any other country. Panchayats, abolition of untouchability, the Indian brand of secularism, equal treatment to all the religions, the concept of positive secularism. Mains mein you need to analyze such type of thing. It is not that you should write the sources of the constitution and then finally you will write, the Indian constitution is a bag of borrowings. Now, from the prelims point of view, you may be asked about the sources of the Indian constitution. I will tell you in brief the most important sources from the examination point of view. Mains mein they will be asking you such questions, or क्योंकि I don't know whether we will be meeting during the mains or not, तो इसमें भी कुछ prospective topics भी मैं आपको बता देता हूँ. And the UPSC is very fond of asking questions in the main examination on the Government of India Act, that what we have taken from the Government of India Act. In the last 10 years, twice the questions have been asked from there. So you should be aware, but दूसरे से नहीं पूछते हैं, they don't ask. Now, what are the major sources? I will tell you some of them, you can write it. The Government of India Act 1935. What we have taken first, the administrative structure, next, the office of the governor, next, the idea of federalism, then the idea of the Supreme Court as a federal court. It was the British who had first established the Supreme Court कहां स्टैब्लिश किया था? फोर्ट विलियम, कैलकाटा. नेक्स्ट, the idea of emergency. The idea of emergency. Then it is only for the purpose of continuity that I am telling you. UK Constitution. Single citizenship. Single citizenship. The office of the CAG. The office of the CAG. Then civil services. Civil services. Then writ jurisdiction of the courts. Writ jurisdiction of the courts. Then parliamentary form of government. अभी मैं बता दूंगा थोड़ी देर में what is parliamentary form of government, what are the features, ये सब. Then rule of law. हाँ, rule of law or equality before law. Equality before law. Not Article 14 as such, because Article 14 has got two parts. One is equal protection of law and one is equality before law. Then US Constitution. The idea of preamble. The idea of preamble. Preamble. Then fundamental rights. Then equal protection of laws. Equal protection of laws. Then the vice president. The vice president to act as the presiding officer. The vice president to act as the presiding officer of the upper house. Of the upper house. Now, when we talk about the American system, in America, the vice president of America is the running mate of America. He has got only one work. That is, he will be acting as the president in case there is a vacancy in the office of the president. So, obviously, you will not be giving salary to anyone to keep on waiting. That is why he has been given the task of presiding over the Senate. We have adopted the same formula here in case of India. Our vice president has also no function to discharge as the vice president of India. He has got only one function, to wait. Wait for two things. The president to go on long leave or long leave the president. And yes, and on both the conditions, he will act as the president or discharge the function. So, यहाँ भी waiting के लिए you will not be getting salary. So, we followed the American model, gave him the work of presiding over the Rajya Sabha. So, he is the presiding officer of the Rajya Sabha. This we have taken from America. Then next, the term of members of Senate. The term of members of the upper house. Term of members of the upper house. No doubt in some of the books you will find that judicial review we have taken from the US Constitution, but no. Judicial review is a part of the American system, but it is not mentioned in the US Constitution as such. It evolved as per the decisions of the Supreme Court in 1803 in the Marbury versus Madison case. It is not mentioned in the Constitution of US. So if loose terms mein people say that judicial review we have taken from America, but not from the American court, technically it can be wrong. That is why I did not mention you. Then another source is the Canadian Constitution. Canadian Constitution. Here we have, from here we have taken a federation with a strong center, a federation with strong center, then appointments of the state governors by the center, appointment of the state governors by the center, then residuary powers vested in the union government or the center. How many of you in the class are not aware what is this concept of residuary power? You all are aware? ठीक है, anyone of कोई दिक्कत? You see, the legislative relations between the center and the state is based on the three lists which have been provided in schedule number 7. List 1, that is the union list. The subjects which are there in the union list, only the union government can make laws. The subjects which are there in the state list, on those subjects the state government can make laws, and the subjects which are there in the concurrent list, both can make laws. There are some subjects which have not been mentioned in any of the three lists. Our constitution makers may not have thought about the need of laws on those subjects. That is why they did not incorporate those subjects in any of the three lists. So the subjects which have not been mentioned in any of the lists, they are termed to be residuary subjects. For example, the subject of space was not mentioned in the original schedule number 7. So when the Sputnik was sent, at that point of time, we felt the need for having a law on space. That is why it became a residuary subject. Then in the era of information technology, we felt the need for cyber laws, as it was not mentioned in any of the three lists. Our constitution makers had never thought about such type of things. So they did not mention it. So it became a residuary subject. So this we have taken from Canada. Then next, the Australian Constitution. The idea of cooperative federalism, the idea of cooperative federalism, the idea of concurrent list, the idea of concurrent list, then Article 301, Article 301, freedom of interstate trade, commerce, and intercourse. Trade means buying and selling of goods. Commerce also means the same thing, buying and selling of goods. But what is the difference between trade and commerce is that in trade, profit making is more important, but in commerce, transaction is more important. Intercourse is going from one place to another place for cultural interaction, samagam, that is intercourse. So this article we have taken from the Australian Constitution, section 92, and we have put it in our constitution. Then Irish Constitution. What we have taken from Irish Constitution? Very good. Directive principles of state policy. Directive principles of state policy. Then manner of president's election. Next, the Weimar Constitution of Germany. Weimar Constitution of Germany. We do not use the word Constitution of Germany. The simple reason is that when our constitution making process was going on, Cold War, and Germany was bifurcated at that point of time. Before that, there was Hitler's constitution, so we had not taken anything from there. And before that, there was the constitution which was enacted at a place called Weimar. So to make differentiation, we use this word Weimar Constitution of Germany. So from here what we have taken, first, the emergency provisions, vested in the center, vested in the center. So what we had discussed, the idea of emergency. If you go through the Government of India Act, your history teacher may have talked to you about this, then the idea of emergency was there under the Government of India Act, but the power to proclaim emergency was there with the Governor General as well as the governors. But this power has to be there with the central government, that was there in the Government of India Act, that was there in the Weimar Constitution of Germany. Then secondly, suspension of the fundamental rights, during national emergency. Then Constitution of South Africa, process of amendment of the constitution. Process of amendment of the constitution. Nowadays, the UPSC rarely asks questions, but we will have to be ready. And in your state PCS examination, such questions can be asked in the prelims examination. So this will be handy for you, this notes for the UPSC as well as for your state PCS examinations also. So, but in the main examination, the question I told you, bag of borrowings, wo kar lena kabhi bhi after you complete your prelims examination, when you prepare the notes for the main examination. And then the Government of India Act 1935 from the mains point. So only 4 or 5 I told you from the prelims point of view, but mains point of view they will be asking you question. These were the aspects that we needed to discuss in this session. We'll take a break of 30 minutes for you, and then I will see you again at 11 o'clock. Okay. Now, welcome back. So, in the last session, we had discussed some of the basic things. Now, coming to another feature of the Indian Constitution, it is a flexible constitution with few rigid provisions. Here also you see that there are two words, flexibility and rigidity. And this is a classification of the constitutions. And what is the basis of this classification? Some of the constitutions are flexible, some are rigid. Here the basis is the process for the amendment of the constitution. So one sentence you can write for your understanding. Based on the process of amendment, of the constitution, the constitutions have been classified as flexible and rigid. So it is based on the process of amendment, how the constitution will be amended. Now, when we say flexible constitution, a flexible constitution is that constitution which can be amended easily. That is, only by the central legislature. Only by the central legislature. The states will have no role here. Then, when we talk about the rigid constitution, here you can write, a rigid constitution does not mean that the provisions cannot be amended, but the process of amendment is a complex one. And after the central legislature passes a constitution amendment bill, it has to be ratified by specified number of the states or the state legislatures. So here the central legislature plus the state legislatures. Now, when we talk about some examples, you can ask me, sir, what can be an example of such a constitution? You see, the US Constitution is a rigid constitution. After the US Congress passes a constitution amendment bill, it has to be ratified by 3/4 of the state legislatures. How many states are there in America? 50. What will be the 3/4 of 50? आराम से सी सेट देना है, बताओ. बैग खोल लो. हाँ, 38, 35, I don't know, 37.5. So it will be 38. So you say that after the US Congress will pass the Constitution Amendment Bill by special majority, then it has to be ratified by 3/4 of the state legislature. It is a tough one, and every Constitution Amendment Bill has to be ratified passed in that manner. Now, when we talk about India, in case of India, we have got most of the provisions which can be amended by the parliament by the majority that we had discussed, but some of the provisions of the constitution, after they are amended by the parliament, they have to be ratified by at least 50% of the state legislatures. So in case of India, such provisions which after being amended by the parliament by special majority that we had discussed, they need to be ratified by at least 50% or half of the state legislatures. They will be termed as rigid provisions. In case of India. But so we have got some provisions. Now from this was your basic. What is flexibility? What is rigidity? So rigid constitution, the central legislature plus the state legislature. How many state legislature should approve it? That depends on the constitution of that country. Now coming to the next aspect of our discussion, that what are the rigid provisions of the Indian constitution, means which can be amended by the parliament with the support of 50% of the state legislatures. So here what we are discussing, the provisions that I will be telling you, after the parliament will pass the constitutional amendment bill, they have to be ratified by at least 50% of the state legislatures. First, Articles 54-55 dealing with election of the president. Articles 73 and 162 extent of the executive powers of the union and states then part 4 of chapter 4 of part 5 dealing with union judiciary. Then chapter 5 of part 6 dealing with state judiciary. Then article 241 it is the high courts for the union territories, high courts for the union territories. Then chapter 1 of part 11 center state relations. Then any list under schedule 7 representation of the states in the parliament. Article 279A GST Council and Article 368 the process of amendment of the Constitution. ये हो गया आपका प्रीलिम्स का. That which of the provisions of the Constitution are rigid in nature? 1 and 2, 2 and then here basically the article numbers can be there or the description can be there. In the Constitution, basically the article numbers have been mentioned. Now there can be a question based on your understanding that why we have got the rigid provisions in the Constitution, why the ratification by the state is required for amendment of some of the provisions. Now if we analyze the provisions that are written here, what we get? Most of the provisions are related to the center-state relations, which aim to protect the interests of the states and also the independence of the judiciary. For example, if you talk about articles 54, 55, so here in the election of the president, the elected MLAs, they also take part. So no amendments can be made here unilaterally by the central government. You can amend these provisions, but you cannot do it, the parliament cannot do it unilaterally. Then here also what can happen? The central can extend its power, means more powers can be given to the parliament. The value of the votes of the MPs will be more than the MLAs. I will tell you about the values of the votes when we will be discussing the union executive. Then Article 73, what is the extent of the union executive power? What is the extent of the state executive power? Then the provisions related to Supreme Court, High Courts, subordinate courts, High Courts for the union territories. This is to maintain the independence of the judiciary. Not a single article of chapter 1 of part 11 dealing with center-state relations can be changed by the parliament unilaterally. And then any list under Schedule 7, union list, state list, concurrent list. No inclusions or exclusions without the consent of the state, 50% of the states. Why? Otherwise, the union, what it can do, it can increase the number of subjects in the concurrent list, or we can say it can cut short the number of subjects in the state list. It can arbitrarily increase the number of subjects in the union list. You can do it, but only with the consent of the states. Then here also representation of the states in the parliament, the same logic. 279A, GST Council. The GST Council, it takes decision with respect to the GST rates, the model GST laws, and in the GST Council, there is the representation of the states also. The Union Finance Minister is the head of the GST Council, and the Ministers of Finance and Taxation or any other minister nominated by the states, they are there in the GST Council. So here also the role of the state is there in taking decision with respect to the GST in the country. No changes in the GST Council, that is Article 279A, can be made regarding their composition, powers, functions, can be made unilaterally by the Parliament. And Article 368, process of amendment. All these aspects, that is how the Constitution will be amended, it is mentioned in Article 368. In the Article 368, ये नहीं लिखा हुआ, this is not there. ये तो I have written it for your understanding. Otherwise, it will be a mechanical thing for you. There will be numbers. So, I have mentioned the explanation here. But in Article 368, it is mentioned that the following provisions of the Constitution, after being amended by the Parliament, they need ratification by at least half of the states. The list is there in Article 368. Article 368 says, I am also rigid. Why? Because if it is flexible, then what will happen? The whole Constitution will become flexible, because the Parliament will amend Article 368 that all the provisions of the Constitution can be amended by the Parliament alone. So, from the prelims point of view, this aspect or that aspect. So, this is important from the prelims point of view. Then coming to another feature. India has a parliamentary system. India has a parliamentary system. In our prelim syllabus, I had told you that there is a topic called political system. And UPSC is very fond of asking questions from this aspect. Now, in the world, there are two major political systems, parliamentary system and presidential system. Now, what is the basis of their classification? The relationship between the executive and the legislature in that particular country. So, before we will proceed further, you can write a sentence here. Based on the relationship between the executive and the legislature, comma, the political systems have been classified as parliamentary and presidential. Underline, based on the relationship between the executive and the legislature. So, in a country, what is the relationship between the executive and the legislature? The classification is parliamentary system, presidential system. One by one, I will tell you. First, when we say parliamentary system, in a parliamentary system, there are two heads. head of the state and head of the government. The head of the state is the nominal head. And head of the government is the real head. In the United Kingdom, for example, in United Kingdom, the head of the state is the crown and head of the government is the prime minister. In India, the head of the state is the president and head of the government is the prime minister. Now, there can be a question in your mind that, sir, if the prime minister is the real head, why not a prime ministerial system? What is known as the parliamentary system? The head of the government is a member of the legislature. That is, they belong to the parliament. So, the parliament provides for the head of the government, that is the real head. Then you will be asking another question that, sir, legislatures in different states have got different names. In the different countries have got different names. So, why parliamentary system? This system evolved in the United Kingdom, which is known as the mother of parliamentary democracy. And in the United Kingdom, the legislature is known as the parliament. That is why the nomenclature, the parliamentary system. So, this is the first understanding. So, two heads. Then, second point you can write here. In the state legislatures, simple majority will be required. Delhi and Puducherry will be included, and when Jammu and Kashmir will have a legislative assembly, they will also be included here. Then it will be 50. When we say state legislative assemblies, wherever we have got legislative assemblies, we mean them also. In the parliament, wherever in the case of a rigid provision, the second type of special majority we had discussed, that will be utilized. Then coming to this aspect, here, second point I was telling you, you can write, the legislature provides for the executive. The legislature provides for the executive. That is the ministers must be the members of the legislature. The ministers must be the members of the legislature. Then thirdly, so here you see all our ministers, they are either the members of the Lok Sabha or the Rajya Sabha. At the state level also you see our ministers are either the members of the legislative council or the legislative assemblies. Then third point you can write, the COM or the COM, Council of Ministers, or the government is responsible to the legislature, especially the upper house, especially the lower house. Lower house means the directly elected house, the lower house. For the first timers, you see what 2 points that we have written. I will explain it with the help of an illustration. Electorate. Electorate means the voters. So in a parliamentary system, the electorate, it elects the members of the legislature and the members of the legislature, they are appointed as the members of the executive. Here we are talking about political executive. So in our country, what we do? We elect our representatives in the Lok Sabha, at the state level in the legislative assemblies, and the party which has got majority or the pre-poll coalition which has got majority, their members become the ministers or the members of the executive. So the members of the executive, that is the ministers, they must be the members of the legislature. There is a fusion. That is, all the ministers, they must be the members of the legislature. But it is not that all the members of the legislatures, they will be the members of the executive. It is not vice versa. And this is the second point we had written. Third point what we had written was, the executive responsible to the legislature, especially the lower house. Lower house means the popular house. So the party which has got majority in the Lok Sabha will be there. Not only this, when we say responsibility, who can remove the whole council of ministers? It is the Lok Sabha in case of India. And if a no confidence motion is passed in this house, that is the lower house, the government will no longer be there. This is the concept of responsibility. So 3 points will be there. Which of the following statement is correct or are correct with respect to parliamentary system? Head of the state is the nominal head, head of the government is the real head. Second, the executive is provided by the legislature. That is, the ministers must be the members. And third, what we have written here, that is responsibility. Now here, if a general question is there, a statement is there, that the executive is responsible to the legislature, then it will be the correct option. But if it is specified that it is responsible to the lower house, then lower house will be the correct option. That is why I have made you to write it. But in place of lower house, if it is written legislature, then that will also be the correct answer. Then coming to the presidential system. In a presidential system, the head of the state and government is the same. The US president, he is the head of the state as well as the head of the government. Then second point you write, a member of the executive, that is a minister, cannot be a minister, what we have written, cannot be a member of the legislature. A minister cannot be a member of the legislature. So there is a clear-cut separation of powers in case between the executive and the legislature in case of a presidential system. You see how the system works. The US case, the electorate it elects the members of the legislature and in separate election it elects the chief executive. The American president is elected in a separate election every 4 years. And when we talk about the US Congress, the legislature there is known as the Congress. It is a bicameral legislature. Senate and House of Representatives. The members of the Senate are elected by the people every 6 years, and the members of the House of Representatives are elected every 2 years. It is just like our Lok Sabha. Now, in case of parliamentary system, what we had discussed, that the party which gets majority here in the lower house, its members become the members of the executive. Here it is not the case. After the American president is elected, then he appoints the persons of his choice as the secretaries. In America, the ministers are known as secretaries. And here what we see is that the president is elected in a separate election. After that, he will be appointing the secretaries. The secretaries must not be the members of the Senate or the House of Representatives. Not only this, in our case, what we had discussed in case of India, if a political party will lose its majority in the Lok Sabha, then the government will no longer be there. Here it hardly matters. Even if the political party of the president of America, it lacks in majority in the House of Representatives, it hardly matters. So they will work separately, they will be working separately. Separation of powers. So from here comes another concept that we need to develop an understanding. It is the doctrine of separation of powers. There is difference between division of powers and separation of powers. We have got the three functions of the state, that is law making, law implementation, and law adjudication. If these three powers are there in a single hand, single institution, it may lead to dictatorship. During monarchy, the king was the sole giver of the law. He used to be the sole implementer of the law and the sole judge. But in democracy, these three powers have to be separated. So that is why the concept of doctrine of separation of powers is crucial for democracy. This concept of separation of powers was propounded by the French philosopher Montesquieu. You can note it. This concept of SOP or the doctrine of SOP was propounded by the French philosopher Montesquieu. So, the three organs of the government, they will be performing three different functions. This is the concept of separation of powers. The logic here, if all the three functions are performed by one organ or one person, it may lead to dictatorship. Then in the next point you can write, in India, as we have a parliamentary form of government, strict separation of powers may not be feasible between the executive and the legislature. Full stop. But Article 50 provides for separation of judiciary from the executive. So in our country, strict separation of powers is not feasible. You see that generally our ministers first of all decide that what type of laws we will be having in the country. Then the ministries, they prepare the draft of the law, that is known as the bill. After that, the ministers, they take part in the legislative business also. They take part in the discussions in the legislature, that is in the parliament. And after the law is passed by the parliament, it is the ministers as the member of the executive, they are responsible for the implementation of it. So strict separation of powers is not feasible. That is why we have got the separation of the judiciary from the executive. So underline kar lena, Article 50, separation of judiciary from executive. But separation of powers is strictly followed in presidential system. So there is a clear-cut separation of powers. Then you can write here as note, NOTE, the doctrine of SOP, separation of powers, has to be accompanied with by the doctrine of checks and balance. What is this doctrine of checks and balance? One organ will put a check and balance the powers of others. Why? Otherwise, if unlimited power is given to one organ, then it may lead to we can say dictatorship of that particular organ in that particular field. For example, if absolute power is given to the executive in the field of appointments, then what will happen? There will be favoritism. So nepotism can also be there. So that is one thing. Absolute lawmaking power is given to the legislature. The legislature can be biased towards one group or the other group, and in the absence of the checks, even the members of the judiciary can go here and there. There may be corruption inside the judiciary also. So there has to be checks and balance in a democratic country. Now, when we talk about India, we have got mechanism of checks and balances that we'll be discussing in the coming classes. In the parliament, we'll be discussing about the parliamentary committees, the motions, the questions in the parliament. So there will be a parliamentary check. Now, if we talk about America, in America, basically, this system of checks and balances exists to a large extent. In the US, if you talk about the legislative check, on the executive and judiciary, all the appointments done by the US President needs ratifications, or we can say have to be ratified by the Senate. By the Senate. All the appointments, ambassadors to another countries, judges of the Supreme Court, if the president decides on the name, the approval of the Senate is required. Then only the person will be appointed. Then all the international treaties and agreements signed by the US President to be ratified by the Senate. Here we are not writing US Congress, the Senate, that is the upper house. Now, why I told you these two things? What is the logic behind it? The simple logic is that in your prelims examination, you can get a statement. Which of the following statement is correct? The US Senate is the most powerful second chambers of the world. It is the most powerful second chamber of the world. If you compare the Rajya Sabha, then House of Lords with the US Senate, not only this, even the French Senate, then the US Senate is most powerful. These powers are not there with the second houses of the other countries. ये जो बोलते हैं ना, it is the most powerful second chamber of the world. So if such unplanned questions will be there in the prelims examination, obviously the teacher had discussed it in that sense. So there is a hearing impact of the class also. You will be able to correlate the things. And then thirdly, the US Congress can remove the president as well as the judges of the Supreme Court by the process of impeachment. In our country, the process is different. But in America, the process is not different. There is the same process for the American president as well as the judges. Deliberately, I told you this point to get you understand one aspect, that the US Senate is the most powerful second chambers of the world. So there is a concept of checks and balance. Not only this, there is an executive check on the legislature also in America. There is an executive check on the legislature, and it is with respect to the president's veto power. With respect to a bill passed by the US Congress. So after a bill, you just need to have an idea. After a bill is passed by the US Congress, it is presented to the president, who can sign or give assent to the bill, or he can return the bill with his remarks within 10 working days. If the session of the Congress is to continue beyond 10 days, and after he will send back the bill, the houses of the Congress will reconsider the bill accordingly, and if the bill is passed by 2/3 majority in both the houses, then the president is bound to sign it. But politically it is not possible. 2/3 in this house, 2/3 in this house, because the president's political party must have representation here in this house and in this house. 2/3 is a difficult proposition. So that is why we say that the deduction that we have is that the American president has got veto power. Means once he will return back the bill, then after that there are little chances that the bill will be passed again. But 2/3 का है, तो इसीलिए बोलते हैं 2/3 डिफिकल्ट है, इस हाउस में भी इस हाउस में भी. देन ये तो हुआ एग्जीक्यूटिव चेक. देन जुडिशियल चेक. On the executive and the legislature. Here we have the concept of judicial review. Judicial review. Judicial review is the power of the judiciary to review a law made by the legislature or a decision of the executive, and to declare it as null and void if it is not in accordance with the provisions of the Constitution or the law. So the US Supreme Court and the US judiciary has got this power. This power is there with the Indian judiciary also. So we have got checks and balances in the American system. तो यहाँ से वो आपको याद रखना है. That is, which house is the most powerful second chamber of the world? Senate. ऐसे छोटी छोटी चीजें that you need to remember. So from the parliamentary system, presidential system, then in some of the countries we have got quasi-presidential system. France, Russia, Sri Lanka. These are some of the countries where we have got quasi-presidential system. It is a blend of presidential as well as parliamentary system. Then you will ask me that, sir, if it is a blend of presidential as well as parliamentary system, then why it is termed as quasi-presidential, not quasi-parliamentary? It is more closer to the presidential system than the parliamentary system. I'll give you थोड़ा सा understanding के लिए I will tell you the French model. The French case. In France, the president is directly elected by the people. Then he appoints a person of his choice as the prime minister. These are the features of presidential system. These are the features of presidential system. Then he appoints other ministers on the advice of the PM. On the advice of the PM. It is a feature of parliamentary system. The PM advises the president to appoint the other ministers. Then the ministers not to be the members of the legislature. It is a feature of the presidential system. And then the ministers take part in the proceedings of National Assembly. National Assembly is the lower house of France. Of National Assembly, and are responsible to it. So, though the ministers, they are not the members of the legislature, but they take part in the proceedings of the National Assembly, which is the lower house, and they are responsible to it. Means a no confidence motion can be passed against the ministers, the Council of Ministers. There is a PM and his team in France, and they can be removed. It is a example of, we can say, the parliamentary system. Then you will say that, sir, how the things can happen? ये होगा कैसे? Because you say that the ministers are responsible to the lower house, that is the National Assembly. Here, while appointing the president of the prime minister, the president will have to take into consideration the aspect that the prime minister has the majority in the National Assembly. If you will appoint another person who has no majority here, then he can be removed through a no confidence motion. That is why in France, sometimes we see cohabitation. Cohabitation. Cohabitation is the president and the prime minister from different political parties. Again, you may ask, that's how such a system will work. PM will be from another political party, president will be from another political party. In France, earlier, when there was no direct election of the president, there was an understanding that president will deal with the foreign affairs, the prime minister, internal affairs. But now we have got direct election to elect the president. And the things have changed there. It is upon the president. The president can assume all the functions, all the powers, and he can simply ask the prime minister and his team to assist him. Or he can give all the powers to the prime minister and his team and he will take rest. It completely depends on the president. So, such type of, we can say, conflict will not arise in case of France. Cohabitation, there is a hearing impact. So, cohabitation, which of the following statement is correct? Cohabitation is a feature of the French system. So, that is what I wanted to tell you. So, even from the prelims point of view, it is not sufficient for us to know that India has a parliamentary system, but the features of parliamentary system, how it is different from presidential system, what is the concept of the, we can say, separation of powers, how it is associated with checks and balances, and then after that, what is the concept of quasi-presidential system. Now, coming to the next salient feature of the Indian Constitution. इतना सारा पढ़ना होता है, ठीक है ना? अगर SSC के लिए और ये सब के लिए, then one liner. India has a parliamentary system. Your work is done. Now coming to another feature, it is a federal system with strong unitary features. It is a federal system with a strong unitary features. Two words here again, federal and unitary. It is also a classification of the political systems. So, just as we do our basics, you can write first, based on the division of powers, based on the division of powers between the center and the states, between the center and the states, the political systems have been classified as unitary and federal. So this classification is based on the division of powers, union government and state governments. Now, when we say unitary system, in a unitary system, there is concentration of powers in the central government. There may be delegation of powers there may be delegation of powers. Now, when we say federal system, in a federal system, there are dual governments. Union or the central government and the state or provincial governments. Nomenclature depends on the country. Here there is decentralization of powers. Now, a bit of explanation I'll give. Examples here: UK, China, France. Here the examples can be US, Switzerland, Canada, South Africa, etc. Now, for those who are studying the subject for the first time, I'll try to make the thing simple for you. Suppose this class is an example of a unitary system. Unitary system will not mean that there are no states. States will be there, but the powers will be concentrated in the central government. For example, here I was talking about this class. If I am the central government and if you people are the state government, then constitutionally all the powers will be concentrated in me, and if I wish, I can delegate some of the powers to you, that on my behalf you can exercise these powers. That is unitary system. Practical example: United Kingdom. In United Kingdom, we have got Wales, Northern Ireland and Scotland. All of them have got their assemblies also. But the power is concentrated in the central government at London. And if the central government wishes, sometimes it delegates the powers to the assemblies of Wales, Scotland and Northern Ireland. And then when it wants, it can take back the powers. That is the concept of unitary system. Now, suppose this class is an example of a federal system. What are my powers? That is the central government's power. What are the powers of the state government? That will be written down in black and white. These are the powers of the central government. These are the powers of the state government. Decentralization of power. Here there is delegation of power. This is the basic knowledge for our friends who are reading this subject for the first time. Now, when we talk about India, what is the nomenclature that has been given to India? The drafting committee held that India is a federal system. It is a federal system. Then a political scientist, Professor K.C. Ware, who had analyzed the working of the system, he held that India was quasi-federal. You see that the drafting committee, which had drafted the Constitution of India, it says that India is a federal system. On the other hand, Professor K.C. Ware, which looked into the dynamics of the federal system, Indian Federation, he said that India is quasi-federal, semi-federal, not fully federal. For me, that is, a student like me will get confused. That what exactly? Because the committee which had drafted the Constitution, it says that it is a federal system. And a person who has analyzed the different provisions with respect to federalism, he says quasi-federal. In social sciences, views are not wrong. Facts can be wrong. Facts can be wrong, views are not wrong. So, here we will have to understand the context in which the drafting committee may have said that India is a federal system, and the context in which Professor K.C. Ware may have said that it is quasi-federal. For that, we will have to understand another basic thing. Essential conditions of a true federation. These conditions have been given by the political scientists. First, a written constitution. Secondly, supremacy of the constitution. Third, a rigid constitution. Division of powers. Then a bicameral legislature. And an independent judiciary. An independent judiciary. UPSC is very fond of asking this question. Which of the following is a feature of a true federation? And in place of independent judiciary, it will be committed judiciary. So students should not get confused. Committed मतलब नहीं है. No, it is not there. क्यों? सर ने नहीं बताया. Straight forward thing. वहां पे दिमाग नहीं सर, why not committed? अरे, you are not political scientists. So basically, most of the students who read even PSI or another, they feel that they are political scientists. Yes, those who appear in the UPSC examination, they feel that they are here to do a PhD on this. Or it is because of compulsion that you are reading this subject. The students forget those things. यहाँ पे in the beginning, that is why I said the political scientists have said it. So in place of independent judiciary, in the question it will be, all the things will be the same. Committed judiciary. Committed judiciary is a negative term. Commitment of the judiciary towards the government in power. So a committed judiciary cannot be a feature of a federation, independent judiciary, so that it will independently arbiter the disputes that may arise between the center and the states or between the states themselves. It should not be committed to this government or that government. So prelims में आएगा तो आप ये सब encircle करोगे. इसके अलावा any point will be there, you should not poke your nose there. Up. India fulfills all the conditions of a true federation. It has a written constitution which is supreme. Because the constitution has to be the supreme law of the land. Why it has to be written? Because the powers of the central government and the state governments, they have to be clear-cut written down in a document. Then a rigid constitution. The provisions regarding the center-state relations are rigid in nature. And then there is division of powers. We have got the three lists: union list, state list and the concurrent list. Then bicameral legislature. We have got two houses at the central level. Lok Sabha represents the popular will and the Rajya Sabha represents the states, and an independent judiciary. The Supreme Court acts as the independent arbiter of disputes that may arise between the center and the states or between the states themselves. That is why the drafting committee may have said that India is a federal system. Now coming to Professor K.C. Ware. Not only Professor K.C. Ware, some of the other Western writers also, they have held that India is not completely federal. Here, such people, what they have done, they have taken into consideration the American Constitution or the American system as the model of federalism. Okay, America is a true federation. If these things are not in your country, which are there in America, you are not a truly federal state. In America, they have got dual constitution, dual citizenship. In our country, we have a single constitution, single citizenship. In India, the states are at the mercy of the center, and Article 3 authorizes the parliament to create a new state. It can alter the area or boundary of the state or even change the name of the state, and the consent of the state is not required. We'll be discussing it in the coming class. Then, during national emergency, the state list is converted into concurrent list, and the parliament can make laws on each and every subject in the state list. If we analyze the three lists which are there in schedule number 7, more number of subjects and more important subjects are in the union list. Residuary power lies with the center. And in case of concurrent list, if both the center and the states make a law on the same subject, it is the union law that prevails. Not only this, under certain circumstances, the parliament can make laws on a subject in the state list. That I will be telling you when we will be discussing the center-state relations. All these aspects I will be discussing with you in detail when we will be discussing the center-state constitutional provisions. Not only this, we have got the governor's office. The governor is the head of the state executive, but he is appointed by the central government. And we have got All India services. And the officers of the All India services, they are appointed by the central government, but they mostly serve in the states. Many other aspects are also there. Administrative directives can be given by the center to the states. Not only this, the major tax subjects are under the union government, and it is not mandatory on the part of the central government to share those taxes with the states. So these aspects we'll be discussing in detail when we're discussing the center-state relation. That is why Professor K.C. Ware may have held that India was quasi-federal. It is the nature of the Indian federalism. So this is the idea. So from here, basically political system, federal system. So such questions can be asked in the prelims examination. That was my intention to tell you about the theoretical thing. Now, these were the basic things. So questions will be there from the parliamentary system, then question will be there from the federal system and some other aspects that we had discussed. Now coming to the framing of the constitution. If I ask you that what you know about the Constituent Assembly, tell me some points about the Constituent Assembly. Don't tell me that the Constitution was enacted, so we can say this many years, days were taken. ऐसे चीज बोलो जिसपे दिमाग पे जोर नहीं देना पड़े. हाउ मेनी मेंबर्स वेयर देयर? अरे ठीक है ना, वी डोंट नो, इट विल नॉट बी आस्क्ड इन द एग्जामिनेशन. कब पूछा? कभी नहीं पूछा. यस, एनी अदर? ओके, ठीक है. ओके, who was the president of the Constituent Assembly? Dr. Rajendra Prasad. Who was Dr. B.R. Ambedkar? What was his contribution? He was the chairman of the drafting committee. Some basic things may be asked in the examination with respect to the Constituent Assembly. The points that you told me, I will just streamline them. You can note it. इसको पॉइंट्स में ऐसे लिख लेना. वो इट इज अ सी ग्रेड टॉपिक. हाँ, there are A grade topics, I'll tell you, the B grade topics and C grade topics. D grade तो पढ़ना ही नहीं होता है. Yes, ऐसे ही मैं आपको पढ़ाऊंगा. The more emphasis I will be giving, it means A grade topic. The lesser means C and D grade topic. वो सिर्फ आपको देख के चले जाना है कि शायद आ जाए, इसलिए. Here you can write the elections for the Constituent Assembly. The elections for the Constituent Assembly were held in July 1946. In July 1946. Next, the members of the Constituent Assembly, the members of the Constituent Assembly were elected by the members of the provincial assemblies, were elected by the members of the provincial assemblies. So there was no direct election, there was no universal adult suffrage also. And your history teacher will tell you about these things, that what was the reason, what was the basis. Then next, the first session of the Constituent Assembly was held on 9th December 1946, it was presided over by Dr. Sachidanand Sinha, Dr. Sachidanand Sinha. Next, the Muslim League boycotted the session. The Muslim League boycotted the session and demanded a separate constituent assembly for Pakistan. Next, on 11th December 1946, the assembly elected Dr. Rajendra Prasad as its president. Full stop. Sir B.N. Rao was appointed as the legal or constitutional advisor to the Constituent Assembly. He was a very learned person, and he was the man behind the Constitution. He was the person who had gone through almost all the constitutions which were there at that point of time, and he was the person who used to give legal advice to the Constituent Assembly. He is the unsung hero of the Constituent Assembly. Many of us do not know his name also. So if you have got some time, sometimes you can see his contribution also, because he will not fetch votes after his name. That is why he is not popular in India. Means he has not been made popular in India. ये तो यहाँ पे है. So because of political reasons, his name is never taken by the political leaders, but he was a man behind the Constitution. Then next, on 13th December 1946, Pandit Nehru presented the objective resolution. This point is asked in the statements. Which of the following statement is correct? Dr. B.R. Ambedkar had presented the objective resolution. Pandit Nehru had presented the objective resolution. So it was Pandit Nehru who had presented the objective resolution. What is the objective of this Constituent Assembly? And at last, this was, we can say, made the preamble of the Constitution. Many aspects were added as the preamble. Then next point, the Constituent Assembly constituted 22 committees to give reports or inputs on various aspects. First, the drafting committee was headed by Dr. B.R. Ambedkar. First, the other members of the committee were Alladi Krishna Swami Iyer, Alladi, A-double-L-A-I-D, Alladi Krishna Swami Iyer, K.M. Munshi, Muhammad Sadullah, N. Gopalaswamy Sadullah. Then N. Gopalaswamy, B. L. Mittar, B. L. Mittar. In bracket you can write replaced by N. Madhav Rao, replaced by N. Madhav Rao, he was not well, so he was replaced. Then how many members the name you have written? 5. Then next, DP Khaitan, he was replaced by T.T. Krishnamachari. He was replaced by T.T. Krishnamachari, as Mr. Khaitan had died, that is why. So from here, sometimes the question can be asked that which of the following was a member of the drafting committee. So K. Munshi's name is the popular one, which is generally asked in the examination. Even your state PCS examination, such questions can be asked. UPSC mein rarely the questions are asked. To maintain continuity, I am telling you. Next point you can write. The assembly adopted the constitution on 26 November 1949. Full stop. From that day, some provisions of the constitution came into force, like Articles 5, 6, 7, 8, 9, 5, 6, 7, 8, 9, 60, 324, then 366, 367, 379, 380, 388, 391, 392, 393 and 394. In bracket you write as per Article 394. So it is mentioned in Article 394 itself that these articles of the Constitution shall come into force from 26th of November 1949. So the list that I have given you, it is mentioned in Article 394 itself. Next point you can write, rest of the provisions came into force from 26th January 1950. Full stop. On that day, the Constituent Assembly ceased to exist, ceased to exist and transformed itself and transformed itself into Provisional Parliament of India, until a new parliament was constituted, in 1952. So this can be another question. Which body acted as the first parliament of independent India? The answer will be the Constituent Assembly. So from 26 January 1950, the Constituent Assembly became the parliament of the country. In the next sentence you can write, 26th November is observed as the Constitution Day. Full stop. The objective of observing this day is to imbibe the spirit of the constitution like liberty, justice, equality, fraternity among the people. So, which of the following is correct or is the objective of observing the Constitution Day? Such type of questions can be asked based on your understanding of the things. So, these were some basic things, but the questions have been asked, and most of the questions here have been asked with respect to parliamentary system and the federal system. The theoretical questions have been asked. Now, coming to the next topic that we'll be taking up for discussion, it is the preamble. You see, every book starts with a preface. What is there in the preface? In the preface, the philosophy of the book is mentioned, is given. The summary of the book is given. Why the author has written the book. In a written constitution, it is not mandatory, but it is customary to have a preface that is termed as the preamble. Certain opening statements which can be there in the examination. It is not customary, it is not mandatory, but customary on the part of a written constitution to have a preamble. So, no political scientist has ever mentioned that there must be a preamble to the constitution. It is customary. It is a prelude to the Constitution. It contains the summary and philosophy of the Constitution. It gives a bird's eye view of the entire Constitution. Bird's eye view is a phrase. When you see something from above, the things are crystal clear. So when you see the provisions of the, you can say, the words which have been mentioned in the preamble, you will have an idea that what type of provisions are there in the Constitution. And not only this, the preamble has also been termed as the soul of the Constitution. No doubt, Dr. B.R. Ambedkar had held that the right to constitutional remedies is the heart and soul, but in the examination, if you are to encircle, that is, which part of the Constitution has been termed as the soul of the Constitution, your answer will be the preamble, because the UPSC in its key had talked about it. That is, the soul of the Constitution is the preamble. When we read the preamble, all of you may have seen the preamble. The preamble says, "We the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens," certain things have not been secured, "and to secure to all its citizens justice, social, economic and political, liberty of thought, expression, belief, faith and worship, equality of status and of opportunity." These things have not been secured. That is why the preamble says, "and to secure to all its citizens." The preamble further says, "and to promote among them all." Promote among them all means promote among the citizens fraternity. What type of fraternity? Assuring the dignity and unity and integrity of the nation. And on this 26th day of November 1949, do hereby adopt, enact and give ourselves this Constitution. We are not supposed to mug it up, but yes, we need to develop an understanding of the preamble. The first important thing that we need to understand in the preamble is the significance or importance of the preamble. First, it declares the supremacy of the people of India. We the people of India. The opening words of the preamble, "We the people of India." What does this mean? This means that this Constitution is not an imposition upon us by an alien power. This Constitution has been adopted, has been enacted by the people of India themselves through their representatives in the Constituent Assembly. It is not an imposition that some country said, oh, you become a republic. Oh, we'll be a republican country. We'll adopt democratic system. It is we who had decided. Our representatives on our behalf in the Constituent Assembly had decided that we will be a sovereign democratic republic. Socialist and secular, these were the words which were added later on. Then, so we the people of India, that is supremacy of the people of India. Then secondly, it contains the ideals and aspirations of the people. Ideals are the goals that we feel that we have achieved. For example, Mahatma Gandhi can be an ideal. A parameter has been set. Swami Vivekanand can be an ideal for some. Dr. Abdul Kalam can be an ideal for some. Honesty can be an ideal. A parameter has been set. Aspirations are the goals that we feel that we have not achieved yet. You all are termed as civil services aspirants because your aspiration is to become a civil servant. You aspire to be a civil servant. Aspirations. So, in the preamble, what the words, that is why I told you the preamble in a very different way, because generally when you talk about preamble, people recite the preamble. They don't talk about preamble, they recite it. We the people of India having solemnly, okay, what is it? You'll have to understand it. So, you see, we the people of India having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic. We have done it. Then after that, and to secure to all its citizens, it means that certain things have not been secured. That is why they have been put under aspirations. And to promote among them all, certain things have to be promoted. ये नहीं आप बोलोगे कि अरे my teacher has said so, that is why. No. You need to know why they have been incorporated as aspirations. So if tomorrow someone will ask you that why they have been termed as aspirations, so you should say that in the preamble you see the wordings, and to secure to all its citizens. Aspirations are the goals that we feel that we have not achieved yet. So and to secure and to promote among them all. That is why such words have been termed as aspirations. So aspirations will include justice, liberty, equality, fraternity, dignity, unity and integrity. That is aspirations. And it contains the enacting clause. It contains the enacting clause, that is the date on which the Constitution was adopted and enacted. That is 26th November 1949. So there is a thin line, hairline difference between the mains and the prelims examination. In the main examination, if the question is analyze thus or bring out the significance of the preamble, in 3 paragraphs you will have to write these 3 things. And in the prelims examination, just an understanding of it. Which of the following statement is correct regarding the preamble? The preamble declares the supremacy of the people of India. The preamble contains the enacting clause. So you'll have to be very particular here. In the main examination, 3 paragraphs, explanation. Your main approach is done. So that is why I had told you that you will have to read the things from the mains point of view. Then only you will be able to answer the questions in the prelims examination. That is why we are trying to develop an understanding. This is the first part. Coming to the second aspect, there is a debate going on. No doubt the debate has come to an end, but the questions are asked even today from that debate. Is the preamble a part of the Constitution? I said it is a debate. It has got two views. One, the conventional view, and the modern view. The conventional view or the traditional view holds that the preamble is not a part of the Constitution, as it is not numbered and the Constitution can very well function even without it. Even if you remove the preface of a book, the book will be there. The page number starts from chapter number 1. Or how many of you read the preface also? So that was the logic. Even if you remove it, the book will be there. This view was given by the Supreme Court in a referral case in the R.E. Berubari Union case. Why R.E. has been written here? ईयर कौन बता रहा था यहाँ से? हाँ बताओ, आर.ई. क्यों लिखा है? रट लिए 1960. हाँ, सुओमोटो. ओके, एनी अदर थिंग? आई टेल यू, कोई बात. इसलिए मैं बोलता हूं किताब पढ़ने के लिए भी गुरु की जरूरत होती है. यू से आपने तो रट लिया R.E. के वो बेरूबरी 1960. आई नो. कोई पूछ देगा व्हाट इज R.E. क्या बोलो? मैं बताता हूं, आज से वही बोलना. यू सी, व्हेन वी टॉक अबाउट द कॉन्स्टिट्यूशन, there are some questions in the Indian polity which will be factual, which will be philosophical, and some will be based on the interpretations given by the Supreme Court. In the Supreme Court, you will have 3 types of cases. That is, we will be discussing 3 types of cases in the coming class. One will be this one, X versus Union of India. X can be an individual, X can be an organization. Union of India, a law made by the Parliament of India. For example, the electoral bond. The name of the petitioner versus the Union of India. Then the Chief Election Commissioners and Election Commissioners, terms of office and the other act. It has been passed, it has been challenged in the court. Then it is X versus Union of India. The name of the petitioner and the Union of India. So it can be a law made by the Parliament or a decision of the Union Executive, Union of India, or any other agency of the Government of India. Then second type of cases will be like this, Y versus State of decision taken by a state government or a law made by the state legislature, if it is challenged, Y is the petitioner and it is the state of. Then third type of cases will be like this. RE. A case has not been filed in the Supreme Court, but this matter was referred to the Supreme Court by the President. That is RE. So, जहां पे भी रहेगा ना RE, referral case, means this case was referred by the President for the opinion of the Supreme Court. So, we have got the advisory jurisdiction of the Supreme Court, and under that, the President can refer a matter of law or fact to the Supreme Court for its opinion. So, whenever a matter is referred to the Supreme Court, the case will be RE, referral. समझ में आ गया? अब there is no need to know the details of the cases. No one is going to ask you. No one is going to ask you the year also. No one. It is simple wastage of time for you. So, even if you remember Berubari, it's well and good. Up. In the Berubari Union case, this matter was referred to the Supreme Court that whether while making laws, we will be following the provisions of the Constitution or the words which have been there in the Preamble. Supreme Court said the articles of the Constitution, not the Preamble. So, one more sentence you can write here. The court held that the preamble is the key. The preamble is the key to open the minds of the constitution makers, key to open the minds of the constitution makers, but it cannot be considered as a part of the Constitution, and thus it is not enforceable in a court of law. Underline. Preamble is the key to open the minds of the constitution makers. So, which part of the Constitution is the key to open the minds of the constitution makers? Answer will be Preamble. Such type of questions will be asked from here. The case may not be asked. The statement may be there in the examination. Then Preamble is not enforceable in the court of law. Now, coming to this view, the modern view. The modern view holds that the Preamble is a part of the Constitution. This view was given by the Supreme Court in the Keshwanand Bharti case. (1973). There is no need of mugging versus State of Kerala case. कोई जरूरत नहीं है. ऐसे में prelims में रहेगा. 4 options will be there. Keshwanand Bharti is there. It's all right. Up. Here you can write the court in this case held that the preamble was adopted in the same manner as the other provisions of the Constitution were adopted. So there used to be discussions and deliberations in the Constituent Assembly. After that, there used to be voting in the Constituent Assembly, and then the provisions were adopted. And generally, our Constitution was based on consensus. So a consensus used to be adopted to be arrived at. Now here also, in case of the preamble, there was a discussion regarding the words which will be there, the expressions which will be there. Voting had taken place, and then the preamble was adopted. So this is the first argument which was given in the Keshwanand Bharati case. Then secondly, you can write the preamble is not the supreme power. The preamble is not the supreme power or the source of any restriction or prohibition but it plays an important role in the interpretation of the Constitution. Underline, the preamble is not the supreme power or the source of prohibition. Another statement which will be there in your examination. The case name may not be there, but such a statement will be there. So, ye nahi ki the preamble is restricting you from doing something. Why we require the preamble? For the interpretation of the Constitution. Suppose directive principles of state policy. So, a question can come in your mind that why we have the directive principles of state policy. In the preamble, the words are justice, socio-economic. So the objective of directive principles is socio-economic justice. So from where we got this objective? From the preamble. So the preamble is not a source of restriction or prohibition. You can interpret the Constitution with the help of this preamble. Then next here you can write, in the LIC case, in the LIC case, 1985, the Supreme Court held that preamble is an integral part of the Constitution. The preamble is an integral part of the Constitution. But it is not directly enforceable, in a court of law, in India. Underline, integral part and not directly enforceable. So this is the latest thing that is there. It is an integral part. What is the difference between part and integral part? क्या कोई मैं बहुत सीरियस चीज पढ़ा रहा हूँ? हाँ, यू आर लुकिंग टेस्ट ऑल्सो. टेस्ट नहीं होना, मैं बता दूंगा कैसे याद रखना है पूरा. ये जो 5 hours पढ़ा है ना मैंने, वो पूरा आई विल टेल यू विद इन 15 to 20 minutes you will be able to recall all these things. Yes. What is the difference between part and integral part? What is a part? Your hairs, they are part or integral part? Part. part. For how many of you these hairs are integral? कभी तुमने बाल कटवाया नहीं कभी? हाँ, कभी कटवाया पूरा बाल? हाँ, उसके बिना सरवाइव तो कर गए, तो बात खत्म. It is a part, not an. What is an integral? This part. ये. It is a. क्या? It is an integral part. Because if it is not there tomorrow, what you will say? There was a teacher who used to teach polity. There was a teacher. So from his, a person will become integral part. Without it, you cannot survive. So the Supreme Court has said that the preamble is an integral part, but it is not directly enforceable in the court of law. UPSC is very fond of asking such type of statements. Directly enforceable. It is not directly. You can file a case in the Supreme Court. Not that secularism is being violated. No. Articles 25 and 26 have been violated, and the word secular has also been mentioned in the preamble. You can go to the Supreme Court by relating the preamble with the provisions of the Constitution. They are not directly enforceable by the court of law. That is what is the stand of the. So from here, the most important things which are asked in the prelims examination is this one. They will not be asking you about the cases. The statements will be there in the examination. So this is one area from where the questions. So ऐसे ही याद, ऐसे ही पढ़ना. जैसे अभी प्रैक्टिस भी करोगे ना. अच्छा, is the preamble a part of the Constitution or not? How many questions have been asked? What type of questions are asked? Then you will also have confidence that yes, I am spending some hours with the teacher and whatever he is teaching is relevant. ये तो टीचर तो कुछ भी पढ़ा के चल जाएगा, हवा भी नहीं लगेगी. Yes, I am telling you the fact. It is the fact. But how? Then confidence will come in you also, on yourself, that yes, I am spending 5 hours, I am getting 5 questions in 5 hours. और कितना चाहिए? 20 क्वेश्चन तो मैक्सिमम पॉलिटी से आएंगे, मैक्सिमम. तो ये चीज. सो ऐसे ही प्रैक्टिस करना. इज द प्रियम्बल ए पार्ट ऑफ द कॉन्स्टिट्यूशन? ये नहीं पूरा प्रियम्बल यू विल प्रैक्टिस. Milestones have to be fixed. Okay, these questions I know, I can answer it on the basis of the lecture note. My work is over. Then I will move on to the next subtopic. The amendment to the preamble. Just write as I am writing here, because it will just be a type of synopsis for you. Prelims में एक बार देख के चल जाओगे, काम हो जाएगा. Amendment to the preamble. The preamble was amended by the 42nd Amendment Act, 1976. Then second part, 3 words were added. Socialist, secular, and integrity. So which Amendment Act had amended the preamble? 42nd Amendment Act. Year, even if you forget, it hardly matters. Then which words were added? Now here in the examination it will be socialism, secular, and integrity. Socialist, secularism, and integrity. You should be very cautious about such type of questions. And the students may be knowing the correct answer, but they may not encircle the correct answer, because they can get excited in the examination. Nearly the students, they make such mistakes in the examination. We call it as human error. You may be knowing, but you have not read the question carefully, but you may be knowing the answers well. So socialist, secular, and integrity. It is a mechanical approach. Then for a deeper understanding, In the original preamble, the words were sovereign, democratic, republic. This is another question from the prelims point of view. The original preamble declared India as sovereign democratic republic. Very easy questions are asked from the preamble. If you see the earlier questions also, test series में they give difficult questions. ठीक है, तो ये है. लेकिन the UPSC is not a, we can say, test of elimination. It is a test of selection. Remember it. So sovereign democratic republic, it was there in the original. So it is another question of your prelims examination. Now here two words were added. After this word sovereign, socialist and secular. Democratic republic remaining the same. Then in the original preamble, the word was unity. Along with this word unity, integrity was added. These are the first sets of themes from where the questions can be asked from the preamble. ऐसे ही पढ़ना है, theme ले लेके, जैसे preamble. Okay, the themes from where the questions can be asked in the examination. Three themes I told you. First, general things, soul of the constitution. Then, significance, some points I told you there. Then, is the preamble a part of the constitution or not? Another theme from where one question. Then, amendment of the preamble, one question. Then, this is the first part of the preamble from where the questions can be asked. Second part is related to the keywords which are there, from where also the questions can be there in the prelims examination. Keywords. In the preamble. No question will be asked in the prelims examination on sovereignty. No words. No questions will be asked. Questions will be asked from the word socialist. Socialism. When we talk about socialism, socialism is, before coming to the Indian dimension of socialism, it is state ownership of the means of production and distribution. A brief idea I will give you that how socialism evolved, because many of you have not taken PSIR as an optional paper, so you need to know some basic things also. From where this concept of socialism came? You say that in order to understand socialism, you need to understand capitalism. Capitalism is private ownership of the means of production and distribution. And capitalism is based on the ideology of liberalism. It is based on the 17th century ideology of liberalism. Liberalism has been derived from the word liber, which means freedom. Liberalism emphasizes on the freedom of the individual. That is the crucial thing that you need to understand. And why? Because the liberals, they have got faith in the rationality of the individuals. Man is a rational being. So rationality is the basis of freedom. Now the second question is, where an individual is free? According to the classical liberals, you may have read in the NCERTs, the word classical liberals means the liberals of the earlier times. They were of the opinion that the freedom of the individual can be best exercised only under the market conditions. You see, liberalization. So, the liberalization no doubt is a modern concept, but it has its roots in the 17th century ideology of liberalism. Because you cannot be free in the society. There are some do's and don'ts of the society. But suppose after this class, when you go home or you go out, you feel to eat something, you have got choice. You can settle for North Indian food, South Indian food, you can settle for a cup of coffee, a cup of juice, anything that you wish, according to your pocket and according to your taste. Then not only this, even if you want to buy a car, first of all, you will decide the type of car that you need to buy according to the needs of your family and your pocket. Then after that, you have a choice, which company? And then after that, a choice of dealers also. He is not giving discount, no, I'll buy from there. So, you are free. Similarly, the seller is also free in the market condition. So, that is from where the things started. The classical liberals basically emphasized that state is the best which rules the least. That is, they favored the concept of a police state, and they held that the concept of the minimal state is good. Minimal state, that state is the best which rules the least. The work of the policeman, maintenance of law and order. The state was considered as a necessary evil. The state was considered as an evil. Why? Because it put restrictions on the freedom of the individual. Why necessary? To regulate the behavior of others. The state was not to interfere in the economic affairs. No developmental functions were to be initiated by the state. And when after this, the Industrial Revolution came, this ideology was the dominant ideology. And under the influence of this ideology, that is liberalism, the states did not enact labor legislations. Economic policies were not made. And then during Industrial Revolution, we saw the exploitative element of human nature. The workers were forced to work for more hours and they were paid lesser wages. क्यों? क्योंकि इकोनॉमिक पॉलिसीज नहीं थी, लेबर लॉज वेयर नॉट मेड, एंड द industrialists, the capitalists were free to have their own rules and regulations. Exploitation of the workers started. And you see, the gap between the have and the have-nots started becoming greater, becoming wider. Why? It was because of the exploitation. Suppose a worker was asked, earlier it was decided that he will be working for 8 hours and he will be paid rupees 1000. It is not an exploitation, but the worker was forced to work for more hours, but he was given the same wages. In the extra time, he will be producing something more. But who will be taking the benefits of it? The capitalist. The worker remained here and the capitalists started becoming richer and richer. The gap between the have and the have-nots started increasing day by day. Economic inequality became rampant, and at that point of time, there came a man with a beard. His name was Karl Marx. Marx challenged the ideology of liberalism. He said, what type of ideology you are talking about? You are talking about freedom? It is because of this freedom that the gap between the have and the have-nots is increasing in the society. And he said, it was not freedom, but economic equality that was the need of the hour. Now, when we talk about any ideology, an ideology first of all explains the nature of the society. Secondly, why the society is like this. And third, the way out. Marx described the society. That in the society there is a gap between the have and the have-nots. There is inequality, economic inequality. The state is dominated by the economically dominant class. Political power is in the hands of the economically dominant class. Then why the society is like this? He talked about this concept, surplus value. The workers were being forced to work for more hours, but they are getting lesser wages. So that was the reason that was given by Marx. Then the way out, Marx predicted that the workers will not tolerate such type of exploitation for long, and there will be a class struggle, there will be a revolution. And in the revolution, what will happen? The workers will overthrow the capitalists. Capitalism will come to an end and there will be established socialism. So how socialism was established? By overthrow of capitalism through class struggle or revolution. I tried to summarize. That is socialism. In socialism, it will be state ownership of the means of production and distribution. The guiding principle of socialism, from each according to his ability and to each according to his work. To each according to his work, which was missing in capitalism. But Karl Marx was the greatest humanist of his time, and he was not in favor of socialism. Socialism was not his end, because Karl Marx was of the opinion that in socialism also economic equality is not feasible. And then came the real philosopher in Karl Marx. Karl Marx imagined that this socialism is a transition period. And during socialism, what will happen? Everyone will become worker. Everyone will become worker. क्योंकि यहाँ भी gap will be there. For example, if I work for 8 hours, I will be getting wages of 8 hours. If he works for 10 hours, he will be getting the wages of 10 hours. If she is working for 11 hours, she will be getting the wages of 11 hours. The gap will be there. The only thing is that exploitation will not be there. That will be missing, but gap will be there. Between the have and economic inequality will be there. Karl Marx said, gradually, during socialism, what will happen? Everyone will become worker. everyone will start going to the factories. Everyone will be getting the same wages, and there will be the end of socialism, and there will be established communism. Communism. Communism is a classless, stateless society. There will be withering away of the state. The state will no longer be there. There will be community ownership of the means of production and distribution. And the guiding principle will be from each according to his ability and to each according to his need. Will not be discussing it in a critical way. That is the domain of our PSI or optional paper. But why I discussed these things with you? Questions that can be asked in the prelims examination. First, which of the following statement is correct? A classless society according to Karl Marx meant prevalence of only one class, that is the workers class. Done? ये इसलिए कि there is a hearing impact. कभी कभी ना ये सब questions पूछते हैं because a basic knowledge is required in the examination. और हम लोग क्या सोचते हैं, who will be setting this paper? ये आपका ये पेपर नहीं है टेस्ट सीरीज का. यस, आपको पता है who sets the test series question papers, but the questions of the UPSC examination, they are given by the professors of the university. उनको नहीं पता you have done only a crash course or you have not read the things in detail. They have got a different vision of a bureaucrat who has got a minimum knowledge of something. That is why they can ask you such questions. Which of the following statement is correct? And here, a classless society means prevalence of only one class, workers class. Those who will go in the examination without any preparation or classless society, oh no class, tick करके आ जाएगा. ये classless है, मजाक थोड़ी ना. But it will be prevalence of only one class, that is the workers class. That will be the correct option. No, you can write here, NOTE. Both Marx and Gandhi, talked about stateless society. Another important statement. Which of the following statement is correct? Gandhiji and Marx, they talked about a stateless society. Here, the reason is something different. Reason is different. Karl Marx was of the opinion that the concept of a state or political authority came with the coming of the classes. When in the primitive communal stage, there were no classes, there was no state. There was no state. Political authority came with the coming of the classes. In the slave owning society, the master and the slave, whatever the master used to say was the law, Why? The master had got economic power in his hand. Then came the feudal society. In the feudal society, the feudal lords who had economic power in their hands, whatever they used to say was the law. Under capitalism, it was the capitalists. And not only this, the state was controlled by the capitalists. State as a class institution. There was no state when there were no classes. Similarly, under communism, there will be no classes and there will be no state. Whether it is a reality or not, that is a different thing. But from the examination point of view, the perspective I am saying, Gandhiji was an anarchist. If someone will ask you, what was the ideology of Gandhiji? Gandhiji was an anarchist. And Gandhiji was also was not in favor of state. Gandhiji used to say that the state tries to curb one violence with the help of another violence. Gandhi's anarchism is known as pacific anarchism, enlightened anarchism. If everyone will be guided by the truth and non-violence, the principles of truth and non-violence, then there will be no need of any authority. So, Gandhiji and Karl Marx, they stood for stateless society. ये हो गई आपकी summary. Because ये नहीं देखते हैं कि whether it is a subject topic of the prelims examination or main examination, a minimum knowledge is required. And one thing you may be knowing or you may not, it is said you can love Gandhi and Marx. Regarding Gandhi and Marx, it is said, love them or hate them, you cannot ignore them. So we have not ignored them. So ये तो हुआ प्रीलिम से, इसलिए मैंने गांधी बोल दिया. In the main examination, you need to write Gandhi ji. Yes, Mahatma Gandhi, Dr. Ambedkar, Pandit Nehru. These are, देखो ऐसे भी we need to give respect to the elders. ये भी एक चीज. So that is why I discussed with you the concept of communism. That was the only logic behind it. To give you an idea of classless society, a stateless one. One more thing that we need to discuss is with respect to the dimensions of Indian socialism. What type of socialism we have in India? We have not followed what Karl Marx had said. We have created from him. That is why I gave you an idea about socialism. Karl Marx had talked about state ownership of the means of production and distribution. We went for mixed economy. Then what Marx had said? Socialism to be achieved through revolution, through class struggle. There will be exploitation. The workers will not tolerate it for long. Consciousness will come in the minds of the workers and there will be class struggle or revolution. Result of the class struggle, the victory of the workers, overthrow of capitalism. But we have adopted Fabian or democratic socialism. That is socialism to be achieved through democratic means, that is the parliamentary laws. That is the parliamentary laws. Regarding now here a word has come Fabian. Here also the public service commissions are very fond of asking that which of the following is correct. India has adopted Fabian socialism. Democratic word may not be there, Fabian may be there. Regarding socialism, it is said, socialism is like a hat which has lost its shape because everyone wears it. It is a famous statement of C.M. Joad. And socialism is like a hat which has lost its shape because everyone wears it. Everyone claims to be a socialist. And in what context? Karl Marx held that his socialism was scientific socialism, revolutionary socialism. Why? He scientifically explained how socialism was achieved and how finally communism will be achieved. Then, so he talked about revolution, of changing the society or bringing socialism. There was another school of thought in United Kingdom, in England. They had established a society called Fabian Society. Annie Besant, then George Bernard Shaw, H.G. Wells, they were the members of the Fabian Society. And the Fabians, they wanted to bring socialism through the parliamentary laws, not through revolution, but through evolution. We adopted that method, Fabianism. So, in the reasoning assertion question, India has adopted Fabian socialism. India wants to achieve socialism through parliamentary laws. How Jamindari was abolished? The Land Reform Acts were passed. They were put in the 9th schedule, and at that point of time it was not subject to judicial review, and Jamindari was abolished. How the nationalization of the banks had taken place? Through the laws. Privy purses was abolished by laws. Even today, the affirmative actions are being initiated through the laws of the legislature. So, we want to achieve socialism through the parliamentary laws. This is the most important aspect from the prelims point of view. You need to remember Fabian, socialism through parliamentary laws, that is democratic means, not through revolution, but through parliamentary laws. Then, the objective. To establish welfare state, and also to establish a socialistic pattern of society. A welfare state is a positive state. So, that is the objective of Indian socialism. How it is to be achieved? Through some of the directive principles of state policy. So, in the DPSPs in part 4 of the constitution, we have some principles which aim to achieve the end of socialism. Equal pay for equal work for both men and women. Prevention of concentration of wealth in fewer hands. The distribution of resources in such a way that it should subserve the common good. Such type of, then right to employment, right to work, as that in some special cases, these are the provisions which are the human conditions of work, including maternity relief. So we have got provisions for achieving the ideal of a welfare state. This is the objective. So in the prelims examination also, they will be asking questions with respect to socialism. It is not the first aspect is there, but with respect to the keywords also, the questions can be asked. These were the things that we needed to discuss in today's class. We'll stop here for the day. In tomorrow's class, in the first 15-20 minutes, we will be winding up our discussion on the preamble. And after that, we'll be discussing part 1, part 2, and then we'll be starting our discussion on the fundamental rights, part 3 of the constitution. We'll stop here for the day.